and it is also the appointed time for the meeting. Please settle down and let us get started, please. Thank you. The topic today is policies relating to foreign domestic helpers and regulation of employment agencies. There are a few papers. Before we go into that, let us invite the administration as well as all the deputations to come in. We have paper, LC paper, number CB2 870 13 to 14 bracket 01. It is a paper provided by the administration. Last time, Mr. Sin Chung Kai said that we should research into the regulation of domestic helper employment agencies in selected places. That has been done, and this is in LC paper IN 07 13 to 14. The background brief has also been prepared by our secretariat, and that is in CB2 870 13 to 14 bracket 02. And of course, we also have a stack of papers, which are the submissions of deputations. They have been sent to members, and also some questions have been issued to us, and they have been tabled. We welcome the administration as well as deputations for coming. On the side of the administration, we have Mr. Matthew Cheung, Secretary for Labour and Welfare. He is sitting in the middle. We also have Mr. Nicholas Chan, Assistant Commissioner for Labour, Mr. Brian Ng Kwok Keung, Acting Commissioner for Labour, Mr. Law Chan Nam, Assistant Director, Immigration Department, and Ms. Lui Wai Fong, Labour Officer from the Labour Department responsible for Employment Agencies Administration. We thank the administration for coming. Today there are altogether 51 deputations attending the meeting today. You please understand that there will be 3 sessions for this meeting because the room is not big enough, and we are going to have 3 sessions. Let us invite the deputations for the first session to come in first. We welcome the deputations. Let me first explain how we are going to make use of the time today. There are altogether 52, or actually finally 51 deputations, because there are too many deputations, and therefore I must apologize to you first of all, and we cannot allow you 3 minutes. We only can allow you 2 minutes for each deputation. Please try to make the best use of the time available to you. In the first session, there will be 20 deputations speaking. Some of them might not have arrived, but we have got time for 20 deputations to speak in the first session, and that will take about 40 minutes. Secretary, I'd like to do this. After the deputations have spoken, I will give the floor to you to give a response. After that, members, please note this, that you will be able to ask questions, but please do not ask any questions of the Secretary at that point. Why not? I will certainly give you the time to ask the Secretary questions, but I'd like to listen to all the deputations first before we put questions to the administration. However, I'd like the Secretary to respond to the views of deputations after each session. And the Secretary should introduce the government's policies by way of a response. And then the time will be given to members to ask deputations questions. And then at the end of the meeting, I will reserve half an hour for members to ask the Secretary questions. I have calculated the time, and I'm sure we should have about half an hour. And after each session, I will leave about 10 minutes for members to ask questions of the deputations. And we really have to manage the time very well so that in the end we really have half an hour for asking questions of the Secretary. This is how I propose to manage the time. In this session, as I said, there will be 20 deputations speaking. So let me welcome the 20 deputations for coming. And I'd like to remind you that if you need to tune in to simultaneous interpretation, channel 0 is the floor, channel 1 is Cantonese, and channel 2 is English. Please make use of the earpiece if you need to use interpretation services. When you speak, please speak into the mic. So first, let me invite the deputations to speak first. But before you do so, I'd like to remind you that whatever you say here will not be covered and protected by the Legislative Council Powers and Privileges Ordinance. And your submissions are not exempted under that ordinance either. Please take note of that point, and if you have not given us any submissions, and if you have got that with you now, you can give it to us after the meeting. As I said, I will now invite the deputations to speak, and then I will ask the Secretary to introduce the policies and also give a response. If some deputations belong to the next session or the other session, I hope they can tune in to the Secretary's speech in another room. So first of all, International Domestic Workers Federation, Ms. Ip Pui Yu, Regional Coordinator, Asia. Thank you, Chairman. With regard to the series of serious abuse of several Indonesian foreign domestic helpers, the administration has never really paid attention to these matters in the past. That is why these Indonesian workers are subject to abuse. First of all, we'd like to reprimand the administration for not having regulated these unscrupulous employment agencies, and the employers. Actually, overcharging has always been a problem, but in the past, the administration has refused to talk to associations of helpers in the community in order to find a solution. In fact, we have already signed the International Labour Convention. In other words, there should be a tripartite consultative mechanism. However, foreign domestic helpers are not included in that mechanism. The administration does not meet with domestic helpers associations. So how we can have a tripartite mechanism to talk about foreign domestic helper policies? Number two, the agency fees. Last September, Akasaka, and also recently, Ariana, they have been abused by employers, and in fact, they sought help from the agencies. However, in the end, they had to go back to the exploitative employers. Why is that so? Because the employment agencies would tell FDH that they would have to repay the agency fees first of all. Now, how much is that about? Usually, if they come to Hong Kong for the first time, especially Indonesian workers, they have to pay $15,000 to $21,000. In other words, the entire salary for the first 5 to 7 months will be given up to the EAs. Therefore, you should attach importance to the International Labour Convention. You have to have a tripartite mechanism and also act according to that convention in order to protect FDH and also regulate the EAs. Next, Hong Kong Catholic Commission for Labour Affairs, Ms. Law Pui Shan, Policy Research Officer. Thank you, Chairman. There will be overcharging and also taking away passports and also forced borrowing. All that has been happening, and it is only through the Vienna incident that now you know how serious the matter is. And EAs actually provide very different services. They do not comply to a service standard. I think you should review the FDH policy. First of all, we think you should abolish the 2-week rule, and you should allow FDH, which make claims against employers and EAs, to stay in Hong Kong by extending their stay so they can do something about their plight. And also with regard to licensing of EAs, you should strengthen the conditions. You should state that when EAs help employers and FDH, they should also help to state clearly the duties, and also you should state that private property, including passports, should not be taken away. And also you should step up your patrol and inspection of EAs, especially those which have breached the law. That information should be uploaded to the web. And also there should be more support for FDH. Those who are in Hong Kong for the first time should sit a one-day course so they understand the laws, the labor laws, and also occupational safety in Hong Kong. What is important is to help them deal with pressure and emotions so they can adapt to Hong Kong life more easily. There should be a 24-hour hotline for FDH. You should not just ask them to dial the government hotline for all departments, because that will not help them to express themselves if they do not use Cantonese. And there should be a hotline to help these FDH. Last but not least, you should regularly and also make surprise checks to the workplaces of the FDH so you know whether the employers indeed provide the conditions as stated in the standard contract for FDH. Thank you, Ms. Law. Next, Amnesty International, Mr. Robert Garden, Asia Pacific Campaign Coordinator, please.
Good afternoon, honourable members of the panel. Amnesty International's research shows that the practice by placement agencies in Hong Kong of illegally charging excessive fees, paying less than the minimum allowable wage and confiscating the passport of migrant domestic workers is widespread. Agencies are able to act in this way as the government's systems of monitoring, investigating and prosecuting unscrupulous agents is inadequate. The regular monitoring of agencies is not thorough or well enough resourced to spot these human and labour rights abuses. Without a law specifically on trafficking for labour exploitation and forced labour, the sanctions available do not reflect the serious nature of the abuses being committed. Instead, the government has put the onus on the worker to provide an unrealistic level of evidence to trigger an investigation, evidence that the agencies and loan companies are adept at hiding. When a worker does make an individual complaint, government regulations act as a disincentive to pursue that claim. Unable to work, lacking an income and somewhere to live for at least 3 months, many understandably decide to leave instead. The result is that many agencies feel they can act with virtual impunity. This state of affairs means that the Hong Kong government has failed in its responsibilities under international law to prevent the trafficking of migrant domestic workers for exploitation and forced labour. The government must urgently establish a robust and adequately resourced monitoring system that allows for proactive investigation of placement agencies suspected of abuses. Those found to be involved in trafficking for labour exploitation must face adequate punishment that reflects the serious nature of the crime. Cooperation with the Indonesian government on these cross-border crimes will be essential. Support must be provided to those workers who file complaints, including allowing them to work whilst their case is going on, and providing assistance in regard to food and shelter in the interim. The Hong Kong government has been criticised by the UN and in the US State Department's Trafficking in Persons report for not doing enough to combat trafficking. In particular, the government was criticised for its reluctance to take steps towards ratifying the UN Trafficking Protocol. Therefore, Amnesty International also urges the government to extend as a matter of priority the UN Trafficking Protocol to the Hong Kong Special Administrative Region. Thank you.
Thank you, Mr. Golden. 跟住係民主建港協進聯盟人力事務副發言人顏文宇先生，唔該。
Next, Mr. An from Democratic Alliance for Betterment and Progress of Hong Kong. Thank you. Yes, we do have a regulatory system on EAs, but it is not comprehensive. The DAB is of the view that we should improve the existing regulatory mechanism and also amend the laws in order to state clearly that employers and EAs have the duties and obligations. We'd like to make the following 4 proposals. According to the law, EAs can charge FDH, but it should not be more than 10% of the first month's salary. However, the unscrupulous EAs usually say that they owe the debt of EAs in their place of origin or other financial companies, so they will have to chase up for the debt. Therefore, the DAB is of the view that there should be a law to prohibit EAs from overcharging FDH. Secondly, with regard to the standard contract, there is not much regulation. Very often, the EAs will include unequal conditions in the contract.
For example, the EAs can breach a contract without paying compensation unilaterally, and we think that standard contracts should be drafted and to clarify the ambiguities to protect the interests of all parties. Thirdly, at present, there is no regulation on EAs collecting service fees, and these EAs may charge various fees under different names. We think that there should be a set of clear guidelines to prevent disputes, and unscrupulous EAs will collude with FDH to abuse the system. So in the sense that after their contracts are terminated, they need to return to the place of origin, and that when they apply for a visa, they need to offer documents in this regard. And finally, the EAs, in relation to the government should actively investigate into any breach against the trade description ordinance. Next, Ms. Choi Kao-wing, campaigner of Amnesty International Hong Kong. Thank you. Last year, the Amnesty International issued a report, and in the survey report, it was found that Indonesian workers were subject to extensive exploitation, but due to lack of investigation by the Hong Kong government or the Indonesian government, that amounted to human trafficking. And before Indonesian workers left their countries, they were required to pay 6 or 7 months their salaries as these fees for EAs. And the FDH are also required to pledge their personal ID documents against the with the EAs for the contracts, and very often these FDH are indebted. And in Hong Kong, we have this 2-week rule and live-in requirement, and if FDHs are subject to abuse or being exploited, it's hard for them to get out of their plight. And the United Nations relevant committee has paid attention to this issue of abuse of foreign domestic helpers. We think that in order to tackle this problem, we should start with the system. We urge the Hong Kong government to, first of all, regulate effectively employment agencies and to tackle the problem of exploitation against FDHs and deducting the salaries unreasonably, and to do away with the 2-week rule and the live-in requirement. And thirdly, in relation to the International Labour Organization's convention, and also the United Nations Protection Convention on protecting the migrant workers, they should also apply to Hong Kong. Next, helpers for domestic helpers, Ms. Holly Allen.
I wish we were not here today because of Ariana. I wish there did not have to be an Ariana case for the government to heed calls that policy changes are needed to mitigate the chances of similar cases occurring. In the light of the publicity surrounding the Ariana case, the Labor Department announced a plan to educate foreign domestic workers about their rights. There was no announcement of any plan to educate employers on respecting the rights of their domestic workers. There was also an excited announcement by the Secretary for Labor that the Indonesian government is considering Hong Kong's suggestion that it grants low-interest loan to finance the fees charged by employment agencies. I'm sure the agencies were equally excited to hear such news, as it would only ensure that they would get paid without the burden of having to make their own arrangement with unscrupulous moneylenders. This would in fact legitimize human trafficking. In short, the Hong Kong government does not seem to get it. Article 7 of ILO Convention 181 provides that private employment agencies shall not charge directly or indirectly, in whole or in part, any fees or costs to workers. Instead of positive changes, government policies relating to foreign domestic workers have become more restrictive. Domestic workers who prematurely terminate their contract, who have been dismissed from their jobs, are penalized by being denied fresh work visas on the grounds that they are allegedly job hopping. In fact, there is little incentive for a foreign domestic worker to change employers repeatedly unless she is being subjected to abuse or poor work condition. Quite the contrary, it's costly for them to job hop because of the exorbitant placement fees they have to pay to find another employer. We reiterate the recommendations laid out in our 2013 submission and provide additional practical concrete ones in this year's written submission. Due to time constraint, I will mention a few of them. The operation of employment agencies against which multiple complaints have been made should be suspended pending the conclusion of investigation by the Labor Department. The time limit for prosecuting erring employment agencies should be extended from 6 months to 1 year from the date the offense was committed. Domestic workers who agree to testify against agencies should be allowed to take up employment. Maximum penalty of $50,000 imposed on agencies should be found guilty if overcharging is too low to serve as a deterrent. The penalty should be increased to at least $100,000. Thank you.
Thank you. 跟住落嚟。
Thank you. Next, Foreign Domestic Helpers Concerned Group, Mr. Michael Lee. We have over 300,000 foreign domestic helpers in Hong Kong serving the families of Hong Kong, and many of these families are the middle class. They are taxpayers, and most couples are also employees themselves. They want to have a fair trade in employing FDH so that they have a helper to take care of their children and their elderly parents so that they can go out and work. However, in terms of foreign domestic helper policy, the government has been favoring foreign domestic helpers instead of employers. Sometimes employers are bullied by the FDHs. And between September and October 2013, we conducted an opinion poll. We collected some 3,500 questionnaires from employers of FCH, and 40% of employers encountered cases of FDH malingering, stealing, bullying children, elderly, and disobeying the employer's instructions. And this year we also conducted another survey. We collected questionnaires from some 1,600 employees, and 25% of the respondents agreed that they had been cheated by employment agencies. And when we asked whether there are effective regulation on employment agencies, 67% of respondents agreed that regulation is not sufficient. And this has been a long-standing problem because there are lots of cases of FDH job hopping and bullying employers, and sometimes employment agencies tell employers that they can pay less than the minimum wage level, and they don't need to give day off to the FDH. And there should be a step up on the regulation and enforcement on the immigration ordinance. And according to the labor laws, is it the case that under the following circumstances, the FDH can be immediately dismissed without paying the wage? For example, misconduct, fraud, fraudulent behavior, or dereliction of duty, or disobeying the employer's instructions. Next, Mr. Jeremy Tam from Civic Party. In the suspected abuse case of the foreign domestic helper, it has caused a widespread concern recently. And in one of the cases, a foreign domestic helper called the employment agency wanting to terminate the contract, but was refused because the helper still owed the agency some thousands of dollars. And in fact, according to our survey, usually the EAs collect $15,000 to $21,000 as their fees, which far exceeds the present legislation. And in fact, according to the second schedule of the relevant ordinance, the fee should not exceed 10% of the first month of salary. And why is it that this law is not complied with? Has the government been doing its gatekeeping job? And in January 2009 to September 2013, in fact, the Labor Department received 284 complaints against EAs overcharging their commission, and throughout the 4 years, only 10 convictions were recorded. But as we understand that most of these employment agencies are charging 4, 5, or even 6 months of the FDH salaries as their commission. And before the suspected physical abuse case, the Civic Party conducted a poll, telephone poll, on foreign domestic helpers, and in fact it's in a written submission. Over close to 80% disagreed to the overcharging of employment agencies, and close to 80% of respondents have no idea that the Trade Descriptions Amendment Ordinance can regulate the service offered by the EAs, because this is under the scope of the Trade Descriptions Ordinance. So one suggestion that we give to the government is to step up publicity of this ordinance on how it is applied also to EAs, and other comments are included in our written submission. Next, Ms. Joanne Choi, Support Group for Hong Kong Employees with Foreign Domestic Helper. Our concerned group, our support group was established 11 months ago, and all along we have been receiving complaints from employers against foreign domestic helpers and EAs, and we have received over 100 cases. So far, the plight facing employers has to do with the overly lax foreign domestic helper policy of the Hong Kong government and the lack of a proper system in regulating EAs. And we have 6 comments. There should be a trial period or probation period for foreign domestic helpers to prevent mismatch and job hopping, and also we can also get a guarantee for a period of time from the EAs, and there should also be a demerit system so that there was an open and transparent complaint mechanism, and to prevent unscrupulous EAs from playing that of defrauding employers and employees and consumers, and also for them to reach the service standards and honor the performance pledge. And we are against the live-in requirement. We support the live-in requirement, because most families with FDH are families with working parents, elderly people, or the disabled. They need to have helpers with living in the premises to help their domestic duties. And if FDHs are allowed to stay outside overnight, this will have an impact on the local labor market, and it will also induce more pressure on housing demand in Hong Kong and other insurance and other social problems. And as for the 2-week rule, we think it should be retained or it should be reduced. And we have more demand than supply, so foreign domestic helpers should not be allowed to stay in Hong Kong for a long time to look for jobs, and they should be sent back to the place, a country of origin, upon completion of contract. Next, Mr. Harris Young from Liberal Party Youth Committee. Good afternoon. I'm Harris Young from Liberal Party Youth Committee. In recent months, we see cases of physical abuse of Indonesian domestic helper, and there have been suggestions that foreign domestic helpers should be allowed to reside outside the place of work, but there are other problems because they need to more time is needed for them to travel to work, and it's difficult to provide comprehensive domestic service to the families. This will impose a greater burden on the families, and the foreign domestic helpers may cohabit with their partners, causing more problems. And we also see a substantial increase in the number of accidental pregnancies, and some employers or some foreign domestic helpers believe that by giving birth to a child in Hong Kong, they could be given the right of a boat, and allowing them to stay overnight could cause more accidental pregnancies in such cases arising.
So apart from giving maternity leave, the employers might also have to take care of the FDH if she gets injured during maternity, and there will be losses caused to employers. Therefore, we must not treat these cases lightly. And also it was expressed by employers that actually FDHs take up part-time jobs on their holidays. If they are allowed to live outside, this will become more serious. An employer once said that an employee said that she was willing to take a smaller salary so that she can live outside and take up part-time jobs. I must emphasize, therefore, that this will cause social problems, and the administration must object to the request and step up enforcement, or else FDH will take up part-time jobs during holidays, and there will be this problem of illegal labor. Thank you. Next, Labor Department, Labor Party, Mr. Peter Shill. I am an elected member of the Eastern District Council. I have received many requests from employers for assistance. Sometimes FDH may borrow money from loan sharks. Then the loan sharks will knock on the door of employers, and some FDHs take up illegal work, and some of them involved in prostitution. And sometimes the FDH would come, and after 1 or 2 days, she makes life so difficult for the employers that she is actually asking for dismissal, so she gets the compensation. I think the situation is quite serious now in Hong Kong. All the policies now seem to protect the workers. There is no protection for employers. I can give you this example that I heard about a few days ago. A resident told me that she hired the FDH. She would just sit there and sleep from the first day onwards. And the whole situation is that she is asking for dismissal. So on the 3rd day, the employer sent her away with compensation. But the FDH would not go. Actually, an agreement has been signed, and then she said, I would have to stay here to look for another job. But the employer said, look, I give you the air ticket, you have to go. And then the air ticket money was given to her, but then after 14 days, she still would not go. And after 14 days, the FDH went to the Labor Department to say that the employer gave her no money, and it was a lie told by the employer. And then the document was presented to the Labor Department, but then the FDH said that she did not sign anything. And then the employer was arrested, and the fingerprint was taken, and there was the release on bail for 3 months, etc. And there was a court case. But in fact, the employer was not wrong at all. And then suddenly, the FDH said, okay, now I would go. And then the employer would have to pay the air ticket money again. So what protection is there for the employer? The Labor Department must also protect the employers. Thank you, Mr. Shiu. Next, Hong Kong Home Service Association Limited, Ms. Choi Chow Ning Ning, Chairman. Thank you, Chairman. Basically, I have been in this trade for 36 years. Now, I'd like to ask the administration to position the matter for us. These EAs, do you regard us as intermediaries, or are you regarding us as service providers? As you know, we are licensed by overseas consulates, and when FDHs come to Hong Kong, we have to take care of them, and we have the responsibility to take care of them. So there will be this management or care fee to be charged, or service charge. So I think the Hong Kong administration should take reference from Singapore and Taiwan, and also the Macau government is also trying to legislate with regard to foreign workers working in the country or place. What about the management fee that should be charged? How should this be resolved? I hope the administration can talk to other places in Asia and also what the mainland see what the mainland is doing, because I hope that we would not be regarded as intermediaries, but actually service providers, because actually we are managing the service as well as an intermediary. Where people say there are unscrupulous EAs, but I hope that you will know that from the administration's information, you should be able to know how many examples there are that EAs have not done well, but actually EAs have been able to bring in tens of thousands of helpers for Hong Kong. Therefore, I hope that we can provide service to society in a healthy and dignified manner. Thank you, Mrs. Choi. And now let us go to the NPP, New People's Party, Mr. Cameron Fong. Thank you. There are over 300,000 FDH in Hong Kong. They come to Hong Kong to help us release our labor, so they are doing a credit to Hong Kong, and at the same time they can also get money to support their families, so it should be a win-win situation. But recently, there was an abuse case, and Hong Kong became the headline stories in the international press. That cannot be tolerated. And people asking questions about the duties and responsibilities of employers and EAs. We have also received a lot of complaints saying that FDHs are involved in job hopping, and they in fact make life difficult for employers so that they are sacked. I think we have heard all these stories, and I'm not going to repeat them. So there are these unscrupulous EAs and FDHs who do not have the right intentions when they come to Hong Kong. In fact, it should be a win-win situation. But then there are many loopholes in our laws, and enforcement is not stringent. That is why we are ending up with this situation. You should immediately review the ordinance, and we have the following proposals. First of all, you have to make a comprehensive review of the EAR. Maybe we should enforce the law in order to see how licenses should be issued. And as for EAs, they should provide stronger support for FDHs. FDH should know what they can do if they are in difficulty. And the administration must also step up enforcement and inspection. Last but not least, there should be a blacklist drawn up for EAs, employers, and FDHs. Thank you. Next, the Vice Chairperson of Labour Party, Mr. Chang Si-lut. Thank you. A series of FDH abuse has been exposed, and we now know the plight facing FDH. These are not individual cases, but it is a system problem. And they do not know the protection for labor in Hong Kong, and they do not get support or assistance from their EAs. So FDHs are in a very disadvantageous position in Hong Kong. They are forced to live in, so they are actually always on standby in the employer's house. The working hours are extremely long, and it is very taxing on their physical energy level, and also even on rest days, before they go out to take a rest and after they come back, they still have to do housework. So they actually do not have one whole day's rest. And also, if they are terminated, they have to leave within 2 weeks. It is just a short 2 weeks. How do you expect someone to land a job in such a short time? Sometimes in order to extend the contract, they just have to swallow the abuse. And of course, the administration should give such information to FDH so that they know where to go for help. And EAs should provide more support so FDHs can help themselves. There is also overcharging by EAs. As you know, FDH only have a few $1,000s in salary, but they have to pay tens of thousands of money to the EAs, so they are always in debt. We believe the consulate in the original country, the host country, should also license the EAs so that there will be joint enforcement. I think more information about these EAs should be released. Thank you, Mr. Zhang. Next, Associasi PPTKI Hong Kong Limited, Mr. Tang Wai-Yuan, Director. We are the Associasi PPKTI. We were set up in 1995. We have 237 member companies. We are the only association recognized by the Indonesian consulate in Hong Kong. We believe that there should be different licenses for FDH and other kinds of labor. As you know, FDH would have to be approved also by the consulates in Hong Kong, and the EAs in their own country would have to comply with the necessary conditions before they are giving a license. And the licensing conditions include a hostel, language interpreters, and also labor counselors, etc. But then the sub-agencies do not have to comply with these conditions, and they are not regulated by consulates. For example, the taking away of passports, overcharging, deducting salaries, no hostels, no interpreters, no counselors. These is what the sub-agencies do. Starting from 1972, when FDHs were introduced into Hong Kong, the Labor Department has always issued the same EA license. Now the Labor Department cannot segregate the FDH EAs and also other kinds of EAs. The Labor Department would only rely on the declaration of the work nature of EAs in order to categorize them. But I believe there should be different licensing conditions for those dealing in FDHs and other kinds of work. Say, for example, only agencies which also are licensed by the host country should be allowed, and they should provide hostel interpreters and counselors, etc. And in fact, very often you rely on the licensing system of the consulates. I don't think that is enough. You should do more joint regulation with these consulates. Thank you. Thank you, Mr. Tang. Next. Policy Group on FDH, Mr. Chen Heng-chung, Vice Chairman. Chairman, members, and also other deputations. I have been in employment service for over 20 years, and I have seen the ups and downs of this trade. I know the situation in the host countries as well as Hong Kong. We have imported labor from Thailand, Sri Lanka, Indonesia, Nepal, and the Philippines. These countries, with regard to protection to their workers and also with regard to the Standard Contract Clause 8, it says that the employer must foot the bill for FDH to come to Hong Kong, and that is why some countries also require the potential or prospective employers to buy or take out labor insurance in the host country, and then when the FDH is in Hong Kong, again there is labor insurance to be taken out for Hong Kong laws. And there have been various changes to these policies and laws, but these are in the host country. But then in Hong Kong, we only have the labor law. We do not have a particular law for the FDH. I think this is why we have the problem. I propose that the administration should set up a dedicated interdepartmental working group to have a tripartite discussion and then update the outdated labor laws. I also propose research in the following directions. First, FDH licenses should just be one category, and if you need to import FDH, you should take out a particular license. And also, you should delineate the duties and rights of EAs. And also, there should be a professional qualification for consultants importing FDH. We can learn from Singapore. And also, there should be protection afforded by EAs for FDHs and employers. I think we should position EAs in a correct manner. Thank you. Thank you, Mr. Chan. Next, Ms. Blondie Hon, Policy Group on EAs. Good afternoon. I've been in the industry for over 10 years. Starting from the Vienna incident, the administration is finally paying attention to this trade. When FDHs come to Hong Kong, we need to provide them with support, and this is according to the requirements of the exporting country. On the other hand, the administration in Hong Kong has not made any regulation in this regard. That is why when EAs provide service to FDHs, we may run the risk of disturbing people or breaching of privacy or even illegal imprisonment, etc. This is because the administration does not have a special category of EAs for importing FDHs. I hope the administration will give us a professional status so that the quality of service will be aligned. I think there should be one particular license for EAs introducing FDHs. This will ensure that FDH in Hong Kong will get the right kind of protection and care.
Yet we have the following suggestions. First, licensees applying for the license for EA should be properly accredited and should be familiar with the application of the labor laws, and he should be familiar in checking the accuracy of the information of employers, a place of residence, etc. And for the domestic helper selected, the EA must provide a medical report together and it should also be responsible for verifying the report. Fourthly, the agency should be responsible for checking that the FDH provides free accommodation and free food, and also every quarter the FDH should return to the employment agency to ensure that she is properly treated. Next, the Hong Kong Chamber of Employment Agencies, Mr. Wong Yifu, Vice Chairman. Chairman, members, at present, the foreign domestic helper policy of Hong Kong was established 40 years ago, but there haven't been many changes. It hasn't evolved and kept up with times, and now it has conflict with other labor laws, and there are also other clashes in terms of implementation. And we have 4 recommendations on the existing policy. First of all, there should be a separate law to regulate foreign domestic helpers and also to regulate standard contract. The so-called ID 407 employment contract contains a number of flaws. In particular, condition number 8 and number 17 on the fees to be borne by the employers and medical examination for FTH, they should be reviewed. And also, at the time of application, in terms of personal particulars, medical report, the FTH should make a declaration as to the truth and should be legally liable. And there should also be a requirement for FTH to regularly fill in forms so that EAs can ensure that the FTH is properly treated. For example, that wages have been paid on schedule and that and with proper rest days, etc. And also for application by employers, the employers should provide information on past records, whether the employee is on long-term medication, whether they have previous records of employing different FDH, etc. And we think that tax concessions should be given for employers hiring FDH. And number 4, there should be regulation over EAs. Thank you. Thank you, Mr. Wong. Next, Association of Hong Kong Agencies for Migrant Workers Limited. Mr. Cheng Ji-Ming, Chairman. Chairman, members, good afternoon. I've been working as an agent for 10 years, and so far we just have employment agencies and with just one license. I have been in the trade for over 10 years. We don't have a separate license for FDH. And when on one occasion the domestic helper was sick, and then I visited her in the hospital, and I asked for more information, and then the hospital said no, due to privacy. And the same helper was arrested, and the police told me due to privacy reasons I could not help her, and also for home visits we could not visit the foreign domestic helper who has been suspected to have been abused. And on arrival, in fact, the foreign domestic helpers have been coached to contact the authorities instead of the EAs. And in fact, according to the Cap 57A, in relation to placement agencies, in fact, no provision is relevant to the agencies that we operate. However, 2 months ago, a different scenario appeared. All of a sudden, employment agencies are required to offer training, etc. And then last month we received a letter, and we have been urged to abide by a certain standard, well, the government finally acknowledges as employment agencies. However, there is no mentioning of the laws concerned, and our suggestion is that we have a separate law on regulating foreign domestic helpers to protect employment agencies, helpers, as well as employers. And lastly, we should have our dignity as employment agencies. 19 deputations have spoken, and like I said just now, some time will be given for Secretary to give his response. It is now 3:20. I hope Secretary would spend 5 minutes to give his response, and then we'll have 5 minutes for putting questions to deputations. If there are no questions, we'll move on to the next session. So over to you, Secretary. Thank you, Chairman. Members, deputations, thank you for attending this public hearing. I have carefully listened to the 19 deputations and their views. I welcome their views. I thank them because there are valuable views and some specific comments. In the recent spate of incidents, we have become very concerned about the issue of foreign domestic helpers in Hong Kong, be it employment agencies or employers, or concerned groups. We understand your concerns. Now, first of all, we attach importance to the rights of foreign domestic helpers in Hong Kong. They share the same rights under our labor laws as locals do. They are protected by the same set of labor laws, same as the rights enjoyed by local workers. And there are misunderstandings that the well-beings of foreign domestic helpers are neglected. But no, we have not neglected their rights and interests and their complaints, and we have been publicizing their rights through various channels. And after the occurrence of recent incidents, we have made it clear that we will step up our effort. We should be forward-looking. Over the past period of time, we understand, and as mentioned by one of the deputations, it's a win-win situation for us. Since the introduction of foreign domestic helpers in the 1970s, we have been able to achieve a win-win situation. We relied on FDH in supporting our families so that housewives can rejoin the workforce, and at the same time the FDH can earn foreign currencies. So we hope to continue to achieve this win-win situation. It is important to bear in mind that FDH is not only just a helper, but a member of the family, a member of the household. And we are looking at how the legislation can be enhanced, how regulation can be stepped up, and we think that first of all, on arrival, we should immediately inform the foreign domestic helpers of their rights, especially for first-timers. They should be informed of their rights and on how to seek help should they encounter problems. And we have different strategies in the short term. We have published in the Indonesian newspapers and also Filipino newspapers published in Hong Kong. Like this one, last week we already posted an advertisement setting out the details on, for example, dialing 999 for help, for emergency, and on the rest day requirements, and on not allowing anyone to take away the ID document, etc. And we will continue to publish certain these advertisements in Tagalog newspapers, etc. Secondly, for local TV stations, the government has APIs, announcement of public information, informing employers of their responsibilities. And this is not just for the sake of employers. We want to emphasize this message that they should treat their employees properly, and also for employees to know how to seek help. Secondly, I appreciate comments from some deputations that we should try our best to help first-time foreign domestic helpers, and we are we haven't decided yet whether it should be a full day or half day, but there should be an induction seminar for first-timers to undertake these courses. This will be arranged by the Labour Department. This is about, as I said, informing them of their rights and on how to seek help during emergency situations. And if time allowed, we can also provide some message on occupational safety. And sometimes in Hong Kong, we have accidents of helpers falling from height as a result of, say, wiping windows or hanging laundry, and we are very saddened by these events, so we need to step up training in this regard. Secondly, we also seriously consider for short, medium, and long term, we need to impose proper regulation. That is, in terms of employment agencies. Chairman, may I be allowed to continue? Just be brief. We will step up or enhance the licensing regime. We may also include licensing conditions. For example, new arrivals should be kept in touch for a period of time so as to ensure they are protected. And there will be other licensing conditions, and no borrowing of money allowed, and employment agencies, if they are banned from lending money, the many problems can be eradicated. But I want to emphasize that even before the foreign domestic helpers come, they are already heavily indebted because they have to pay hefty fees as commission for the employment agencies. And although the local employment agencies only charge 10% of the first month's salary, according to the latest figure, we do not allow overcharging. So it has to do with the root of the problem, and we discussed with the Indonesian government that with the training fees and the agency fees should be handled properly. If in their country of origin this can be dealt with properly, their debts will not be carried forward to Hong Kong. So, Dr. Fernando Chen, you have a question for deputations? Because if you have a question for the administration, you can wait till the last session, wait till 5 p.m. Is for the deputation right? 2 minutes, please. No time. Thank you, deputations, for coming. I have heard different views. We also have representatives of employment agencies, and as for EA fees, and I'm not talking about fees charged by local EAs, but by the country of origin, it's very prevalent. Many foreign domestic helpers get heavily indebted before they come. Now, these employment agencies would withhold travel documents of foreign domestic helpers, and this is also a common scenario. So my question for the deputations is this. I don't think they want to follow this practice either. Some few EAs might be black sheep of the family. So in their view, how can we eradicate this problem of overcharging EA fees and withholding travel documents? How can this be eradicated? Now, who or which representative would like to take this question? For EAs, maybe not about eradicating the problem, but just tell us the real picture. Any confiscation of travel documents, any overcharging? Who would like to tell us more? Mr. Chang. For training fees and agency fees, many stem from the country of origin. I think it's feasible if the fees can be directly transferred to employers, if this is acceptable to employers. I mean, because we are the agency, and for these fees, we are not involved.
As for confiscating passports, that's impossible. Sometimes There may be unscrupulous agencies withholding the passports. It is not confiscation. Or else how can FDHs go back to Indonesia? Dr. K.K. Kwok, Chairman, as the Secretary said, the administration is saying that it has discharged its duties because it can only regulate local EAs. It cannot have jurisdiction over Indonesia or the Philippines. Now, can I ask the labor organizations, do you agree with the Hong Kong administration? Do you think the administration has already done its best to protect FDHs? Ms. Yip. We also do a lot of labor education. When the Labor Department does not do it, then we are the ones to do it. And I can tell the Indonesian FDH that the agency fee should be 10% of their first month's salary. But no FDH believe us because it is not working. Education does not work because you are not monitoring the situation. You are not talking to the Indonesian government to coordinate the protection for FDH's rights in order to put an end to overcharging and an end to exploitation by EAs. So education doesn't work. Would any other deputation like to speak up? With regard to stepping up publicity and information dissemination, I think you should do it, but you should also do follow up and allow them to get actual help. I hope you can put forward more concrete proposals instead of just saying that you will step up with publicity and promotion every time there is an incident. Do FDHs have the confidence in lodging a complaint?
That overcharging happens only in Indonesia or the Philippines or the country of origin. It happens a lot in Hong Kong. We provide legal advice to foreign domestic workers, and majority of our cases involves overcharging by employment agencies in Hong Kong. When they arrive in Hong Kong, and agencies take them to money lenders in Hong Kong to sign false loan agreement. They don't receive any money. Of course, the assumption is the money goes directly to the employment agencies in Hong Kong, and then they have to pay monthly through 7-Eleven. So let's stop passing the buck to the government of Indonesia and the Philippines. Otherwise, the Labor Department will not do anything to monitor agencies in Hong Kong if we keep passing the buck and say it happens only in countries of origin. It happens in Hong Kong.
Last but not least, I will allow the administration to respond because it was said that the two countries should work together. And also, regulation by the Labor Department is such that there should be more monitoring done. Ms. Chen Yunhan, I'd like to ask Mr. Zhang a question. Mr. Zhang, when he first spoke, he was quite angry. He said that he had operated an EA for over 10 years and he had wanted to help the FDH. But when he approached the administration, he was not paid any attention. Right, because we have no status. In the eyes of the administration, there have not been any FDH intermediary. The term was only mentioned in the last 2 months, and we only operate as employment agencies. We are not FDH intermediaries. But no, from the news, I have heard that some have been approved by the Indonesian government. What about your agency, Mr. Zhang? I have a license from the Indonesian government. Well, since you are so outspoken, why is the Hong Kong administration turning a deaf ear to you? Well, I don't know, because there is no FDH intermediary and we do not have an FDH law. However, the secretary said that he cares a lot about you. Well, no, he only regulates us. He doesn't say he cares about our work. But when the FDH come to you for help and you go to the administration for help, then the administration should pay attention to what you are saying. But you are telling us that no one pays attention to you. That's right. Even if I go to the police station to bail an FDH, the police don't talk to me. I go to a hospital to help FDH, no one talks to me. I think I need the administration to answer my question. If he has a license, why is he treated that way? I think what Mr. Zhang is saying that yes, he has a license, but he is just regarded as an employment agency. But it seems the administration starts to pay attention to them now. And so Mr. Zhang is asking for a proper status. Well, of course I want a proper status. We have no status. We are just regulated. Oh, that's very strange, because I have heard from the news that those which are approved by the Indonesian government are operating properly in Hong Kong. Okay, it's now my turn to ask a question. Mr. Tang or Mr. Zhang or the Indonesian Association can answer this question. There are 200 EAs which are approved by the Indonesian government. And then, in fact, anyone else can be an EA. Now, how do the two relate? Is it that some are sub-agencies? Because they have to go through you before they can get workers to come from Indonesia. So, is it that two fees are charged? I'd like you to explain the framework to me. I think it is important that you are here today because there will be transparency of the entire workings of the system. And secondly, the employers pay, right? The employers pay the intermediaries. And then the FDH also has to pay $21,000. Where does the money go? Employers pay you. Now, I don't know what your fee is like. Maybe $6,000, $10,000 from employers, and altogether you received $30,000. Where does that money go? Can we have more transparency, Mr. Tang or Mr. Zhang? These are two questions. Or Ms. Han? Well, actually, the Hong Kong public say we will withhold the wages. They misunderstand that we charge 5 to 7 months salaries. Many of us are here today. In fact, we do not charge even $1. Sometimes we have to pay out of our pockets. That is why the agency fees are now from $6,000 to $10,000. This is because the money has to be paid to Indonesian and Philippines training agencies. You mean you don't get a cent of the $21,000? That is why you are charging $6,000 to $10,000? That's right. Then do you also have to pay the Indonesian side? Well, this is the market rate. But in fact, we have to pay $1,000 to $2,000 from our own pocket to those countries of origin. In fact, it is $2,000 multiplied by 6, so it's about $12,000. Well, the FDH also pays a fee in Indonesia. That is legal. The Indonesian Labor Department allows the EAs in Indonesia to charge that money. 13,000? But why are they asked to pay 21,000 in Hong Kong? Well, you give the evidence. No, I mean, in Indonesia, $21,000 are charged. Is that right? I do not have evidence. 21,000 is outdated. It was many years ago. It used to be 21,000. Right now, the Indonesian government stipulates that it is $2,543 multiplied by 6. So it's about $15,000, and this is collected by banks designated by the Indonesian government. Okay, thank you. Because of time constraint, I cannot allow more answers to be given. There was this question about the relationship between sub-agency and agencies approved by the Indonesian government. Okay, we will welcome the next round of deputations. Thank you very much. And if you are interested, please go to the public gallery to attend the rest of the meeting. Thank you very much, members. We'd just like to have some status so that we can continue to operate. Thank you, Mr. Zhang.
Okay. 你去廁所洗手間係啦，啱啊！即係呢個時間就最好大家去洗手間。咁或者我講下啲即係開。
Okay, let me make some introductory remarks. The Secretary for Labour and Welfare has stepped out of the room, but he will soon be back. If you need interpretation service, please wear the earpiece. If you have a problem, please ask for help. Channel 0 is the floor, Channel 1 is Cantonese, Channel 2 is English. I'd like to remind you that whatever you say here and also your submissions are not covered or exempted under the Legislative Council Powers and Privileges Ordinance, so please be mindful of what you say here at the meeting. Each of you will have 2 minutes. After you have spoken, members will be able to ask you questions, and then later on, members will talk to the administration, so you will be the ones that will be answering questions after you have spoken. There will be altogether 19 deputations in this session. Because of time constraint and since the Secretary for Labour and Welfare is back, let us get started. The first deputation. United Filipinos in Hong Kong, Ms. Dolores Baladares, please.
Yes, good afternoon, everyone. Our submission, the problem of paying big amount of money to the recruitment agencies are rampant. Foreign domestic workers are victims of scrupulous agencies. In the Philippines, there is a POA guidelines. It states that all household service workers need not to pay agency fee to the recruitment agencies, but in reality, applicants are charged from 85,000 pesos or 120,000 pesos, equivalent to 15,500 Hong Kong dollars up to 20,000 Hong Kong dollars. But according to the Hong Kong Employment Ordinance, a worker shall only pay 10% of her first month's salary to the recruitment agencies, which is equivalent to 410 only. Worse, in order to pay the placement fees, recruitment agencies arrange for an applicant to apply for a loan with a money lending agency payable in several monthly installments to be deposited in a designated bank where the applicants are required to open a current account. Another modus operandi is to pay the loan in Hong Kong to the money lending agency to be arranged by the Hong Kong-based counterpart agency. Upon arrival in Hong Kong, the foreign domestic workers stay in the boarding house of the recruitment agency for 2 to 3 days. During this period, the recruitment agency will either endorse the applicant to a money lending agency, or they are informed to pay their loan either through 7-Eleven or directly to the Hong Kong money lending agency, and the terms and amount of the monthly installment. Agencies instructed employers to make sure that the foreign domestic religiously pays the loan. To ensure this, employers will open an account for the foreign domestic workers with an ATM card. The employers deposited the monthly wage but withdraw the money
咁個僱主咧就會係入嗰個月薪落去啦，咁但係咧就會用個提款卡攞翻出嚟嘅。咁如果個工人咧拒絕呢一個安排嘅
Yeah, thank you. 跟住落嚟係Miss。
Thank you. Next, Miss Mission for Migrant Workers Limited.
Hello. No.
Oh, sorry, I read the wrong name. It
Sorry.
should be Mission for Migrant Workers Limited, Ms. Norman Oy-Kane, Program Coordinator. I'm sorry, Aaron. Thank you.
The matter in this policy discussion is this. Fundamentally, domestic workers are supposed to be a labor employment matter. However, Hong Kong pays lip service to this because, in fact, the whole scheme is determined by the Immigration Department. Unfortunately, the Labor Department either agrees to this or are forced to do so, as proven by the administration's submissions today. In most countries, it is the Labor Department that supervises the actual terms of employment of workers, whether domestic or overseas. The role of Immigration Department is just to check if there is any objection on immigration grounds to the admission of the worker. Once the worker is admitted, it is then the job of the Labor Department to supervise the conditions of employment. But not so in the case of Hong Kong. The dominance and jurisdiction of the Immigration Department has crafted infamous policies such as the 2-week rule, the live-in requirement, the new policies on screening applications for change of employers, which meddles in the field of employment conditions. The role of the Labor Department should be central to the scheme, as it is only the Labor Department that has the power to enforce the Employment Ordinance, which applies to both employment and supervision of EAs, or employment agencies. The immigration does not have the power to enforce the terms of the contract against the employer, nor regulate employment agencies. Immigration Department does not observe the terms of the ILO conventions. That is the Labor Department's province. It is lamentable that the Hong Kong government, through the Immigration Department, should resort so easily and frequently to criminal law and administrative policies to restrict and punish those whom it should otherwise be protecting under the International Labour Conventions. We believe that major policy reform is urgent and required, and it should start with enforcing the Employment Ordinance without discrimination and ensuring the principality of jurisdiction of the Labor Department, not the Immigration Department, on matters related with foreign domestic workers. Thank you.
Thank you. 跟住落嚟係香港人。
Thank you. Next, Mr. Lang Heng K from Hong Kong TKI Association Limited. Now, foreign domestic helpers, they earn only $4,010. On MPF, they don't even reach a level requiring them to pay MPF contribution. Now, no matter how long they work, even for working for 5 years or so, they don't get any protection because they leave out of their own volition. They don't get any protection from employers. So I hope the government would look into that. The other point is that I hope on falling from height, I hope you can make it mandatory that they wear fall arrestor or wear a lifeline, because every year we see accidents like these. It's very easy. They can install an anchorage point on the window frame, and that will help protect them. I hope government would consider it. And recently, last August, the Immigration Department, in relation to foreign domestic helpers who have prematurely terminated their contracts, well, the Immigration Department has suspended their applications for coming back to Hong Kong, but I think they should be banned. Mr. Mohammed Aslam from Ethnic Minorities Youth League. Yes, I speak Cantonese. Chairman, members, now, when foreign domestic helpers arrive in Hong Kong, they may have problems in terms of their Chinese or English language proficiency, and they might not be good at expressing their problems. They could only tell those problems to their fellow helpers. And apart from EAs, no one else could explain to them the details of the contract. And as soon as they arrive, they are forced to sign the contracts. They may not clearly understand the conditions. So the EAs are very important. They should be responsible for explaining the conditions to them and the terms of the contract. And that's one point. The other point is on before they arrive, in terms of their accommodation, food, clothing, other livelihood issues. After they arrive, coaching is needed. And without EAs, I don't know which party will be responsible for it. I don't know which organization can be responsible for helping foreign domestic helpers on these important issues. Recently, I have a friend who was a foreign domestic helper, and she passed away on completion of the contract, and the employer refused to help because the contract had been completed and she had no relatives here, and her body was left in the mortuary. I was wondering whether any government department could be responsible for helping with her funerals. Next, from Commercial Organization and Domicile Services Employees Association, Ms. Chow Kwai Ying. Good afternoon. About the abuse of foreign domestic helpers, we feel really helpless, and it's a sad incident, and very often we see conflicts between FDH and employers. And even for local workers, we sometimes see local workers being bullied by employers. Therefore, the government should enact legislation to protect domestic helpers as well as foreign domestic helpers. And about commission, I understand from foreign domestic helpers that sometimes they're required to pay a fee equivalent to 3 or even 4 months of salaries. Despite the hefty sum, the EAs are not required to be legally responsible for them. So let's imagine a woman leaving her place of origin, coming to Hong Kong to report duty. The place is unfamiliar to her, and many of them are first-time home leavers, and if they're required to leave the country and live live outside, and should there be any accident, who should be responsible? Employers, EAs, the government, or what? Our association, therefore, strongly opposes allowing FDH to reside outside. There could be many problems stemming from this suggestion. So the important point is for the government to enact legislation to protect FDH and as well as employers. Now, an FDH told me that when she applied to come to Hong Kong, she was supposed to take care of the elderly people, and yet after she arrived, she was taking care of a baby instead. So I hope the government would legislate on it to reduce conflicts and misunderstandings so that we have a harmonious society. Thank you. Next, Mr. Lau Chang-mo, Director of Hong Kong Union of Employment Agencies. Yes, I'd like to talk about liabilities. Other points have been covered by deputations. I won't repeat them. And recently, there have been suggestions to reduce the training fees for FDH, but that has to do with the fees paid before they arrive. That is, whether the fee should be borne by employers or by FDH. However, if it's to be paid by the employers, it should be stipulated in the contract. And for Clause 8 of the contract, I think we need to be very careful because there could be ambiguity here, so that in the future the employers may be responsible for it. To avoid any dispute, we should amend Clause 8. And Mr. Matthew General Secretary also suggests that regulations should be stepped up. Yes, we are for regular home visits, but this is not listed as a licensing condition. I hope the government can have different sets of licenses, one for ordinary EAs, the other for EAs for FDHs, and there are over 1,000 or even 2,000 licenses for EAs, but for those accredited by the Consulate General on for Indonesian domestic helper 267 and some 368 for Filipino FDHs. Only these accredited EAs can import FDHs. Now, for the remaining EAs and remaining FDHs, where do they come from? What is the source of these FDHs? We see media coverages talking about job hopping. Now, when the government amends the legislation, they should consider setting up a separate license for FDH. Next, Mr. Aaron Saradoy, Asia Pacific Mission for Migrants.
Benchmark for the protection of domestic workers' rights, the ILO Domestic Works Convention, or C189, and other pertinent ILO statutes should also be a point of reference for the Hong Kong government in its formulation of legislation and policies that apply to all MDWs. We take exception to the following existing policies and laws in the SAR that are contrary to the spirit and intent of the provisions in the C189 and other ILO conventions. First, the mandatory live-in policy of the Hong Kong Immigration Department. This policy has created conditions that are ripe for the maltreatment of domestic workers, including overly long working hours, physical and mental abuse, rape and sexual harassment, and violations of the domestic workers' cultural rights. The C189 provides that domestic workers are free to reach agreement with their employer or potential employer on whether to reside in the household. Second, unregulated work hours. Regulation of working hours is stipulated in the C189, specifically in Article 10(1), that directs members to ensure equal treatment between domestic workers and workers generally in relation to normal work hours, overtime compensation, periods of daily and weekly rest, and paid annual leave in accordance with national laws, regulations, or collective agreements. Third is the 2-week rule for those with terminated contracts. Obliging terminated MDWs to exit Hong Kong increases their vulnerability to debt bondage. Debt bondage is also considered a form of slavery under ILO Convention No. 29, or concerning forced or compulsory labor, which the Hong Kong government signed in July 1997. Fourth is the weak monitoring and prosecution of erring placement agencies. We believe that there are inadequate mechanisms and policy gaps for regulating placement agencies operating in Hong Kong. Article 15D of C189 requires that ratifying ILO members ensure that adequate machinery and procedure exist for the investigation of complaints, alleged abuses, and fraudulent practices concerning the activities of private employment agencies in relation to domestic workers. And finally, we recommend that for Hong Kong government to harmonize the temporary migrant laws of Hong Kong with the spirit and intent of the ILO Domestic Workers Convention and all other international labor statutes. Thank you very much.
Thank you, Aaron. Mr. Rob.
Yes.
Thank you, Mr. Rob Connolly.
Good afternoon. I've prepared written submissions which deal with 5 separate policy areas, but I think for the sake of speaking, I'm going to focus on which one I believe is the most pressing and the one for which the Hong Kong government bears the greatest responsibility in exacerbating the situations that lead to abuse in the very sad minority of cases. We've heard a lot about the symptoms here, but not so much about the cause. And I believe that one of the key causes of abuse of domestic workers in Hong Kong is the 2-week rule, as it's commonly referred to, or the new conditions of stay. That is an administrative policy that was brought in 1987, and one which has been criticized by international human rights bodies, such as the UN's Human Rights Committee, the CESCR, the CERD, the CEDAW, CEDAW, and we also languish in Tier 2 of the US Department of State's Trafficking in Persons report, largely for this issue. And it's because the administration seeks to stop job hopping, which actually doesn't exist, because it's very costly for a worker to change employment, but in fact merely limits freedom of contract. That is, workers who are in abusive employment situations fear leaving their employment because of the fact that they will have to leave Hong Kong within 2 weeks and incur further agency fees from overseas or stay in China or Macau, where such matters are not regulated before they return. If there was a single issue that I would ask the administration to deal with, it would be this one. We have a new administrative policy brought in last year to screen abuses of the policy for job hopping, and with a separate policy existing to catch abuse, there's no justification for maintaining the 2-week rule.
Thank you. 跟住落嚟，香港家庭傭工。
Next, Hong Kong Employers of Domestic Helpers Association, Mr. Joseph Law. Thank you, Chairman. We have received many complaints from employers. So 6 years ago, we have asked the Labour Department and LW Bureau to step up enforcement, but we have not had any proactive response. So we hope the Labour Department will look at the complaints received by us, and we'd like to make the following proposals. First of all, there should be a special complaint receiving mechanism for FDH-related matters, and it should be widely publicized. Secondly, the existing hotline cannot discharge its proper function. Number two, all the EAs and the entrustment documents should be in uniform format. Complaints have been received from employers saying that the documentation used are in different formats. Number three, there should be a guideline for operation, including penalties. If there is serious breach on the part of EAs, there could be revocation of license. And also we should review whether in the law we have sufficient powers for enforcement and prosecution. Next, the EAs should not force employers to accept another FDH if the chosen one does not come to Hong Kong. We believe within 45 days, if the chosen FDH does not arrive in Hong Kong, then a big part of the fees should be returned to the employers. Next, the Labour Department is the licensing agency, and it should take up the responsibility for receiving complaints, doing monitoring, and also doing investigation. You should not ask employers to go to the Consumer Council, which does not have prosecution or investigative powers. Last but not least, we hope the administration can state that the Philippines consulate should not be dealing directly in the contracts. Now the Philippines consulate can do it, but the Indonesian consulate is not willing to do it, and the employers have to pay tens of thousands of dollars to tackle contractual problems. Thank you. Next, FDH Agency Problems Concern Group, Ms. Liu Ming Chu. Good afternoon, everybody. The administration licenses EAs, but you only tackle the symptoms of the problem. Employers have also told us that Hong Kong laws actually do not protect employers. Employers have to pay a fee to employ FDH. But why is it that nobody protects the employers and nobody supports us? The employer will say he hires an FDH and he is at the mercy of the system. The EA only releases part of the information, say the CV of FDH. Of course, we trust the EA's CV information, but we would ask whether this particular FDH would suit the situation in the home of the employer, and the EA would always say the FDH would know Cantonese, and if she needs to take care of children, she will be excellent in providing the care. And if you say you have an elderly person, they would say the FDH is excellent in taking care of elderly persons and escorting them to doctors or hospitals, etc. But then when the FDH arrives in Hong Kong, you will find that actually the FDH doesn't know Cantonese at all, and the EA will say something else then. they will say, actually, it is very difficult for the FDH to learn Cantonese. It is very little that they are using. But then if you also ask that the FDH has to take care of children, but if she doesn't use Cantonese, then what would happen if the children fall sick, maybe have a fever, and the FDH would have to take the children to a doctor, but then there will be no way to communicate. And then the EA will say the CV is only declared by the FDH and it has not been checked by the EA. Now, I believe the administration should stipulate that the CV should have been checked and verified by the EA. I think you have to tell the EA also to train the FDH. The administration should stipulate the content of the training course, and actually the EA should seek to understand and check the background of FDH before introducing them. Thank you, Ms. Liu. And then FDH and employers should be strong. Ms. Quindy Chow. I would say that for employers, we are having so many problems. The FDH's work attitude, and I think everything has been slipping. This is because the administration is not doing its monitoring role. The FDH are job hopping. They always make life difficult, so they get sacked, and they would actually turn the air ticket into money, and the EAs also stand to gain. And also there could be 1 month's salary in lieu of notice if the FDH are sacked. So employers lose money. They also suffer psychological pressure. And the Immigration Department, since August last year, has not done anything to stop job hopping by FDH. The situation has not improved at all. I would ask the administration that you should protect our rights. First of all, you should stipulate that within the first year of the contract, if FDH do job hopping, they should be repatriated and they should not be given another work visa, so that the visa quota can be given to other FDH who really want to work in Hong Kong. And number 2, you should review the immigration ordinance. If FDH do not exactly leave Hong Kong for 2 weeks, if they just go to Macau to get another work visa and come back to Hong Kong to take up another job, then actually they have not gone back to the place of origin. I hope this will be reviewed so that in that case, employers should not have to pay the return ticket because it is totally wasted. I hope the administration will really tackle these problems of job hopping by FDH, plug the loopholes, protect the rights of Hong Kong people, so Hong Kong families can live and work happily, so that we can continue to fight for the benefit of Hong Kong. Next with Ms. Helen Wong from FDH Agency Concern Group. Thank you. I am a victim. I'm a member of this concern group, and many of my friends have also been victimized. The immigration and labor laws of Hong Kong are very unfair to us. It says if we terminate the contract, FDH should return to the place of origin by the most direct means. If they do not go back, if they just go to Macau, Guangzhou, and come back, and then they can go to another employer. But employers like us have to pay about $2,000 for the air ticket, and we also have to pay 1 month's salary in lieu of notice. We believe the law is not ideal, and therefore the FDH are job hopping, and the number is increasing. The labor law also stipulates that if they break something at home, at most they will have to compensate $300. But many articles in my home have been broken. You should review the law because we have been victimized by FDH. And also, EAs have a lot of business, and therefore some of them are persuading FDH to job hop. So if they go to a new employer, EAs will then have even more business in terms of agency fees. That is why we think that this is a criminal, and yet they are not taken to task. I also heard our chairman say that if you don't go through an EA, the Indonesian consulate will not give the visa. I hope you will try to understand why Philippines is helpful, but the Indonesian government is not willing to do this. Okay, next. Ms. Leung Bronthy from FDH and Employers' Rights Protection Group. Thank you. Actually, we have a serious problem now. The quality of FDH is slipping, and this is because the policy is inclined to favor them, and EAs are unscrupulous and they are cheating us for more profits. Now the law does not regulate EAs, so unscrupulous ones get introduction fees from employers. They also have air ticket money, and they are still telling FDH to job hop, and in fact sometimes they introduce FDH to us who cannot actually work in Hong Kong, but sometimes we have no choice, and they do not abide by the spirit of the contract, and that is why we have a FDH of lower quality nowadays. In order to improve the EA system, we believe the administration should introduce a demerit point system for EAs. And there should be a licensing system for EA operators, so they know what the law requires of them, and so that they will not provide partial information to mislead employers. It is just like estate agents and insurance brokers. They have to attend examinations in order to get a license. Very early on, Singapore has got this system for employment agencies so that they are on a par with other professional people. And society will find EAs more acceptable. I would actively ask the administration to learn from the Singaporean example, that you should have a demerit point system for EAs, and also in the long term, you should have a licensing system for EA employees themselves, so they have more professional knowledge, and in the end we can protect employers as well as employees. Thank you. Ms. Lian Chan from FDH Policy Concern Group. Thank you, Chairman. According to the standard employment contract, when FDHs come to Hong Kong, when they go for body examination, etc., all the fees are paid by employers, and then we have to pay salary, medical attention and meals, etc. According to the Liberal Party survey, you need to expend $7,000 to $8,000 every month on an FDH. This is by no means a small amount for the average middle-class family. Right now, when FDH apply to work in Hong Kong, they have to go through EAs, and employers do not know these FDH beforehand, but EAs are of different standards, and they sometimes do not have professional knowledge, so employers know nothing about the FDH before they come. The administration therefore must come up with concrete measures to protect the rights of employers. We believe you should consider setting up a 3-month probation period. In those 3 months, the agency can only get part of the agency fees from employers. And after the probation period, the employers will have to pay up the entire agency fee, so that we will know the FDH before they come to Hong Kong.
And also, I hope that the immigration ordinance can be reviewed so that prospective employers can request the employee to provide the past record of their performance and their work record in Hong Kong to offer better protection to employers. 跟住副主席係Filipino Migrant Workers Union Eman Villanueva 先生。講翻咧，香港政府咧就好嘗試係去掩飾佢一連串嘅外傭政策嘅失誤，就話咧係想防止外傭跳工。政府就話外傭跳工嘅成因咧就好似係即係同個遣散費有關啊，同你其實咁樣講係好天真嘅。首先呢，如果佢哋做少過12個月嘅話，佢哋攞唔到遣散費嘅。咁另外呢，佢哋嗰1個月嘅費用啦，同埋係
even half of what the agencies charge us. There is no rational or practical reason for an FDW to job hop. We should note that the 1,372 applications are only suspected job hoppers based on unreasonable and arbitrary criteria of the Immigration Department. Of these, 170 were rejected based on unproven allegation of job hopping to collect payment. The 158 who voluntarily withdraw their application cannot also be conclusively classified as job hoppers. The Security Bureau is not even making a mountain out of even making a mountain out of a molehill, but actually creating an issue where none exists at all. They want to project that we are abusing the system, whereas the truth, the system has failed Erwiana and all foreign domestic workers in protecting our rights and well-being. The 2-week rule, mandatory live-in employment arrangement, and other exclusionary policies of Hong Kong have made what happened to Erwiana possible. The truth is that Hong Kong policies are seriously flawed and have in need of immediate and comprehensive changes. The government should stop the lies and the scaremongering, the malicious claims of job hopping, and making it appear that foreign domestic helpers are engaged in criminal act, though there is no law against job hopping in Hong Kong, are unjust and make Erwiana and all foreign domestic workers victims twice over of a system that abuses and enslaves us. Thank you, Mr. Chairman.
Thank you, Eman. 跟住落嚟係 Indonesian
Next, Indonesian Migrant Workers Union, Sri Gatin.
Mr. Chairman, Hong Kong Occupational Safety and Health Ordinance should cover migrant domestic workers. Because last January, an Indonesian migrant domestic worker fell to her death while cleaning windows from the 27th floor of the flat where she worked in the Wong Tai Sin. In August last year, an Indonesian migrant domestic workers, an 18-month-old child fell to their death from 19th floor flat in Yautong. That the same month, another Indonesian domestic fell while cleaning windows in the flat in Bayview Terrace, Tuen Mun. In February 2011, another Indonesian domestic worker also fell out from the 22nd floor flat while cleaning windows in Satin. This and other similar occupation-related death or injuries among migrant domestic workers of different nationalities have been peppering the page of Hong Kong newspaper since the territory began taking migrant domestic workers, begging for policies that will prevent or at least mitigate the recurrence of such accidents. And yet, the reality is that migrant domestic workers in Hong Kong are not even covered by Hong Kong Occupational Safety and Health Ordinance, Chapter 509, that would have obligate employer to abide by standard of workplace safety. What currently applies to migrant domestic workers by way of safety nets for workplace injuries in the Employment Compensation Ordinance, a reactive package of compensation entitlement that serve to ameliorate injuries or death that have already occurred. There are little or no preventive measure availing for migrant domestic workers, such as what local workers in Hong Kong have. Ironically, local domestic helpers are included in the coverage of Chapter 509, which tend to enhance the perception among migrant domestic workers. So we request to Legislative Council to address the concern and amend the Occupational Safety and Health Ordinance to include and coverage migrant domestic workers. Thank you, Mr. Chairman.
Thank you. 跟住係香港。
Thank you. Next, Ms. Fly Lam, Organizing Coordinator of Hong Kong Confederation of Trade Union. On the 18th of June 2013, we had a similar situation at the meeting of the Manpower panel, and many deputations which spoke that day also came today. And that day, they came to talk about employment agencies. And it was almost a year ago, and we raised some issues today. Those issues have been raised back then, but the government did nothing. And in August 2018, the CTU and our affiliated organizations met with Mr. Chan and Ms. Loy from the government, and we also reflected once again the problems with employment agencies, and we also talked about the Indonesian helpers with some loan cards and letters from financial companies asking how these issues should be handled. No response was given. And now, after the serious abuse case of Ms. Ariana happened, we are still looking at whether the government would do anything. And just now, during the first session, the foreign domestic helper concern groups and other deputations are all asked the government to regulate EAs. Unless, Mr. Matthew Cheung, you're lazy, unless the department is lazy, I don't see why we should continue to not regulate EAs. And we have a number of requests for the names of EAs, which are the subject of many substantiated complaints. They should be uploaded onto the Labour Department website so that foreign domestic helpers as well as employers can know the names of these EAs being complained. This can effectively combat unscrupulous EAs. Secondly, many foreign domestic helpers are first brought to financial companies to take out a loan on arrival. And what should the government do? The government should investigate into these cases and see whether commercial crimes are involved. Foreign domestic helpers are forced to repay loans, and this amounts to human trafficking. The loans might have been taken out in Indonesia, but they're required to repay the debt in Hong Kong, and the Hong Kong government should not turn a blind eye to this situation. Something must be done. And another problem stemming from Ms. Vienna's case is that after the foreign domestic helper is subject to abuse, there is no accommodation available to look after her. So there should be some shelter for the foreign domestic helpers in Hong Kong. I'm sorry your time is up. You have just 2 minutes, and let's see if further questions will be put to the government. Next, Ms. Gassing from Hong Kong Federation of Asian Domestic Workers Unions. Good afternoon, Chairman, members. I thank the opportunity for me to give our views here. This is the second time we attend a meeting, as mentioned by Ms. Lam. We've been working in Hong Kong for close to 20 years. Every time when we stage a protest, we submit letters to the government urging the government to resolve problems. So far, we don't see this situation being changed. Now, we're only asking for one thing. The government has listened to different views today, deputations, employers, EA's representatives, and FDH groups, so on and so forth. We're asking the government whether a tripartite meeting can be held, including the government, employers, and labor unions, to discuss long-standing problems and see how the government can resolve these problems, whether the government understands our problem, whether the government knows what we want to do. I think in this tripartite meeting, we can discuss these issues. At the next meeting, the employers can put forward their proposals, and all three parties, in fact, can put forward their proposals, and so that we laborers have protection, and so that employers can live a harmonious life here. And so I've been working here for over a decade. My employers is very good to me. But for other foreign domestic helpers, I also want them to live happily and work happily in Hong Kong. Thank you. So the floor is open. You can put questions to deputations. And for the Labour Department and other government officials, they have noted down many questions, and I will give time for them to give an overall reply. Mr. Poon Siu Ping. Thank you, Chairman. Thank you, deputations, for coming to give your views. Just now, Mr. Law asked that Mr. Joseph Law said that 6 years ago you already urged the government to impose regulation. Can you tell us more on your proposal, how the regulation should be done? Mr. Law, about 6 or 7 years ago, our association had this hotline 2885 and so on and so forth, and every day we receive dozens of calls from employers asking for help. And about 6 or 7 years ago, our employers started to ask questions on the relevant legislation, and from these questions they started to ask other questions on employment agencies, and they suspect themselves of being cheated by them. And because we very often have meetings with the Labour Department and we discuss issues on that foreign domestic helpers, including the relevant laws and the wages, I already raised on those occasions that the government should regulate the employment agencies. But as mentioned, the government has not actively responded to these issues over the years. I look forward to a response from the Labour and Welfare Bureau. This is just a preliminary proposal that I put forward just now. I hope that the employers' bodies, including our association, can have a meeting with the Bureau and also the Labour Department. And when we regulate employment agencies, we understand that Hong Kong is a free market, and we must aim at providing a level playing field. So that's why I said just now that 6 years ago I already urged the government to regulate EAs. Ms. Chen Yun Han. Thank you, Chairman. Well, just now, Mr. Law said 5 or 6 years ago you started discussing with the government, but the government hasn't given you any reply. Has it to do with the complaints against or by foreign domestic helpers today? Do you feel that the government has changed its stance afterwards? Well, in fact, we have adequate laws in Hong Kong, but technically, for example, there is no code of practice on regulating EAs by the Labour Department, no licensing conditions, so different EAs have different practices. For some employers complain to me that after signing, say, an authorization letter, CHOP may be stamped on it the following day, unknown to her. And this is very unfair to employers. That's why we need to standardize and regularize things. EAs should not be allowed to do whatever they want. For example, if the FDH doesn't come, no money will be refunded. There is no standard at all, no discipline at all. Yes, save your questions to the last session. Well, just now the Labour Union suggests a tripartite meeting between the government, employers, and Labour unions. Would that be more direct?
Mr. Law, personally, I think the administration should listen to the views of different parties. But perhaps employers' associations and then employees' associations and EA associations may have a conflict of interest among them, so I believe the administration should meet them separately instead of having a joint meeting, or else there would be more talk than action. Chairman, Well, I think it's better to have a joint meeting, isn't it? Because we are talking about how the parties relate to one another, right? You are talking about a tripartite meeting, that I understand. Any other questions? Mr. Leung Kwok Hong, please only ask the deputation's questions, not the administration. Save your question till 5 o'clock if you have one for the administration. I'd like to ask the employers, how do you view the EAs? Do you want more EAs? Is it that you like more EAs to be improved in quality? Would anyone like to take the question? Improving EAs. Can I please answer the question? Yes. Mr. Councillor, do you have an FDH? No. Then you don't understand the feelings of employers. No, he is asking you how to improve the quality of EAs. EAs operate a business. It has to get a profit because it has to pay high rent. Now, if you ask me how this should be improved, it is actually a social issue. Employers also said that you would like to monitor and regulate the EAs. So who can take that question? I can continue. Yes, please. When EAs import FDH, they used to have a lot of authority because the administration has been very lax with the monitoring. They only need a business registration to operate an EA. But as some other deputations have said, could we ask them to be licensed in a special way, that there should be a code of practice or guidelines to be issued for them to follow? Mr. Law? Chairman, I'd like to clarify something. Let me give you an example. There are different industries and trades in Hong Kong that should be licensed, like restaurants. They are licensed by the FEHD. And usually, there are licensing requirements and conditions to say if you don't keep the toilet clean, you don't keep the kitchen clean, if there are cockroaches in the kitchen, you will be prosecuted, etc. But the Labor Department doesn't impose such licensing conditions on EAs. That is why there is no law enforcement. Okay. Lastly, I'd like to ask a question. I also asked that question in the first session. Maybe Mr. Lau can assist me. You said that some of you are accredited or approved by the Indonesian government. Some are not. If you are accredited by the Indonesian government, those who are not should go through you in order to do business. Does it mean that people have to pay twice? One for direct service and then another one to get a job by the Indonesian consulate? Are you talking about the sub-agencies? Yes. In fact, we have said many times that there should not be sub-agents. I said that the FDH intermediary service should be separated from the average EAs. And that is why now those who do not have the license will have to borrow a license from other people. If the FDH is in trouble, they don't know how to contact her families. They get $400 from people, but people don't understand why $410 are charged. In fact, that is the agency fee, and then that sub-agent has no other responsibility. But the employers are paying the agents. They pay $8,000, right, instead of $400. Normally, if you hire a FDH, you pay $8,000 to $12,000. I think the administration is now confusing matters. There is a training fee instead of an agency fee. I can give you this document to read. You read it, you will know the course structure and why Indonesian helpers have to pay $13,209. What is that? Before they come, there are 6 cooperatives accredited by the Indonesian government, and they would have to already take out a loan with these 6 cooperatives before they come to Hong Kong. Please submit this, allow me to submit this document. Yes, give it to our staff, and it will be copied to the relevant parties. Now we go to the next round of deputations. So thank you very much for coming. If you are interested, you can go to another room or retire in the public gallery to follow the rest of the meeting. In the third session, we have 12 deputations coming. Welcome, deputations. Now, because of time constraint, I hope we can start right away. But let me just remind you that Channel 0 is the floor, Channel 1 is Cantonese, and Channel 2 is English.
Now
I would call upon the deputations to speak now. In this session, we have 12 deputations. I hope each of you will take 2 minutes, and then the Labour and Welfare Bureau will respond, and then we will have questions for you. First of all, Thai Migrant Workers Union, Executive Committee Member Ms. Parichat Jaramonong. Good afternoon, Chairman. Today, I'd like to tell you the real situation. Because I am an FDH. I think many people have talked about our situation. There are many issues. They have not just happened. They have been here for a long time. But the situation has not improved. So I'd like to know how you view the situation. Many people say that we like to get sacked, that we will do everything to get sacked because we want to have a free air ticket. And then we have 2 weeks to get another employer because we still have the visa. The 2 weeks and also the employer's money actually do not benefit us. And that is not fair to us. We like to stop discrimination for FDH. Don't just listen to employers, also listen to us. We come to Hong Kong to make money, to help our families. We don't come to Hong Kong to have a good time. We also come to Hong Kong after paying a lot of money. We also take out loans before we come to Hong Kong. So if you say we do everything to get sacked, it's not to our benefit, because if we cannot get a new employer within 2 weeks, we have to go back. And when we come back again, we have to pay the agents. So please understand our situation. Next, Ms. Sheila, Chairperson. Progressive Labor Union of Domestic Workers, Hong Kong.
We are here again for the second time. Last year we are here. We again hear everything from the agencies, from the labor unions, from organizations and other local groups. Now we are doing the same thing. We are hearing all these happenings in Hong Kong. But last year we have submitted our results of our survey with the Labor Department and all other government agencies in Hong Kong. Since then, this is now again like duplicating what we have done last year. What we want now is response to our submitted proposals so that we can work out some protection for migrant workers and also protection for those employers, as we are saying here. Since we keep on talking about this protection, but there's no such coming from the government, any suggestions or proposals or any dialogues for us as workers. Until now, we're still waiting for our response to our submitted statements and proposals and recommendations to government offices. What we want now is really the real situation. You have seen everything. You have heard everything. So what we want now is the decision from the government how to protect our workers in Hong Kong. Thank you.
Okay, thank you, Sheila.
Next, Sri Lanka, Hong Kong Employment Agency Association Limited, Ms. Yan Chang. Thank you. Good afternoon. Indonesia and Philippines actually are the main countries exporting workers, but then the situation in their countries is improving, so they have adjusted the policy. Like Taiwan, Singapore, and South Korea, they are also making a high demand for FDH. Therefore, there has been a decreased supply of experienced FDH to Hong Kong in recent years. Because there is a higher demand than supply, therefore Hong Kong employers have to pay a higher cost to hire FDH. We hope we can open up other markets so different nationalities can be brought into Hong Kong to work as FDH. Then this will help relieve Hong Kong employers from high expenses in hiring FDH, and there would be a stable supply of FDH in the short, medium, and long term. Since there is a tight supply of experienced FDH in Hong Kong, most of the FDH come to Hong Kong for the first time to work, and in the first few months, it is a learning period or adaptation period for them. And then they may not meet the expectations of Hong Kong employers, and that is why there has been premature resolution of contract. I hope the administration can help. The Labor Department can do employee retraining, etc., and other subvented organizations can help to provide professional training so as to enhance the quality of FDH and also to improve the attitude of FDH. On the other hand, we don't expect to have a double-edged sword. For those FDH actually, for employers who always have early resolution of contract, there should be some regulation. And when they hire FDH again, they must also go through training courses by the administration so that both parties will take a first step.
Thank you, Ms. Chow. Next, from Union of Nepalese Domestic Workers in Hong Kong, Mr. Zhang. Well, the executive committee member is coming today because the government has always, well, the committee member is unable to come today, So I am speaking on behalf of the union because the government all along has refused to hold meetings on weekends, and the executive member has to work on weekdays. Now, one of the EAs submitted a written submission. They are not attending this meeting. It shows that they are profit making in nature, and about the Bangladesh organization, their submission is that they should charge 10% each month instead of a one-off fee, and then the long service payment should also be scrapped. But if, like the EA said, if they are just charging fees legitimately, and then that they are not making profit out of the fees charged, then shouldn't all EAs go bankrupt soon? And also the commission of $2,000–3,000. But according to the Indonesian government's papers about the fees to be paid by foreign domestic helpers, well, that kind of fee is not included. So there are two different versions here between the two governments, and if our government doesn't do anything, then in the end we won't be able to find the truth. And very often it's said that there is no sufficient evidence, and very few cases, very few EAs are prosecuted. And this document is provided by a staff member, former staff member working in an EA, and this document shows how the EA forces the foreign domestic helper to sign on it to take out loans, that the ID document is withheld. The paper is now circulated to all members as well as government officials. Next, Ms. Doris Lee.
We believe that the system of importation and labor of migrant domestic workers to Hong Kong requires major reform immediately. First of all, as we saw in the case of Ariana, domestic workers are not being properly protected against abuses. And as Hong Kong citizens and employers, as well as ordinary citizens, we are really concerned that this will continue. A number of measures have been recommended for many years, as the service centers and unions have already said, for ending these discriminatory and exploitative rules, such as the 2-week rule and live-in requirement. These are deeply violating women workers' rights and really set the value of discrimination against women workers by the government, and we think this is wrong. The workers are not just sheep that you can keep behind fences to stop them from running away. This treatment of human beings is a shame to the whole society. We would like the government to take a proactive role in ending this mistreatment of human beings, which is happening more and more, and which is attracting attention around the world now. Educational TV advertisements will not be enough. The government should allow workers in Hong Kong to live out or take other measures to provide more child care and elderly care, which is the real concern of the employers who are hiring domestic workers. We should not rely on a system that relies on trapping women workers like mice in a cage. Secondly, the role of recruitment agencies. As we have been hearing from both employers and domestic workers, their role in the creation of many of the problems is very great. It is very clear that the more domestic workers and employers change employers or workers, the more the agencies profit. The Consumer Council has already reported a high number of complaints of employers, and we are really unhappy that the government is not taking action either for the complaints of employers or for the complaints of workers. We have heard enough cases of the workers being cheated. We also do not think that opening the market to domestic workers from further and further away will help, because some of the major problems are language, culture, and cost. Thirdly, we oppose the establishment of a self-regulatory body of recruitment agencies. This is asking wolves to police themselves among the sheep. The government must take a firm role, and many concrete suggestions have already been given. Thank you very much.
Thank you. 跟住係威盛公司。
Next, Wellshine Company, Mr. Timothy Leung. Thank you, Chairman. As a newcomer in the EA industry, I am in all support for a tighter control over EAs. But in the process, I hope we can consider 5 requests and 5 points, including the Hong Kong government and the government of the place of origin of FDHs and EAs and employers. Unless we believe that one link can be done away with, for example, some may suggest that EAs could be phased out. Otherwise, consideration should be given to the fact that every link along the chain makes contribution. And when accusations are made against the performance of FDHs and intermediaries, we need to consider the different interpretations of these 3 groups under the law. Some foreign domestic helpers may be accused of forcing the employers to sack them so that they get something, the gain out of it. And sometimes employers may also make undue demands which might be the gray area of the law. For example, on weekends, on Sunday morning, employers will sometimes ask a foreign domestic helper to finish some chores first, but it's not just some chores. By the time the chores are finished, it's almost afternoon. So in terms of legislation, the government should be clearer. Thank you, Mr. Leung. Next, Ms. Bangong Tamason, spokesman for AMCB.
By this time, the world knows about the abusing of Ariana, so we urge the panel to not treat Ariana's case as an isolated one. It is extreme, yes, but it definitely is not isolated because abuses, physical, emotional, sexual, of employers and recruitment agencies happen to many of us in many and different forms and degrees. We also urge the panel to take actions that will lead to reforming of this policy, which has, firstly, new conditions of stay or 2-week rule. It is the overarching policy that puts the security of livelihood of foreign domestic workers always at risk. The new conditions of stay must be reviewed thoroughly as recommended even by the UN Committee for the Elimination of Discrimination Against Women. Secondly, mandatory live-in employment. As shown by Ariana's case, this policy is one that can make abuse to be kept hidden until they get really worse. Live-in employment arrangement should be made optional and based on the mutually accepted agreement of the employer and the foreign domestic workers as stipulated by the ILO Convention number 189. Thirdly, exclusion of foreign domestic workers from the statutory minimum wage and the regulation on working hours. It does not show a progressive step away from social exclusion. This must be corrected, and at the same time, this should not be repeated in the current process of discussion on instituting a regulation on working hours. Last but not least, we would like to close with the message of Ariana to our event, the 1 Million Rising for Justice. She said that, I hope my case will be the last. I don't want any more people to end up like me. So pitiful, the fate of small people like us. Thank you, Mr. Chairman.
Thank you. Next, Bethlehem House Migrant Women's Refuge, Edwina Santoyo.
Thank you very much. In 2013, Bethune House provided shelter and welfare services to more than 600 women migrant workers, mainly Indonesians and Filipinos, who were forced to terminate their employment due to the contract violations, non-payment and underpayment of wages, long working hours, illegal work, insufficient food, unsuitable accommodation, verbal, physical, and sexual abuse, or those terminated for various reasons such as health-related issues, recruitment agency, and money lending agency problems. These depressed conditions of migrant workers are aggravated by the provisions of the Immigration Department's two-week rule policy, which prohibits migrant domestic workers from taking up employment while police, labor, or other cases are being heard or claims being processed. Despite condemnation from the United Nations Committee on the Convention of the Elimination of All Forms of Discrimination Against Women and its Committee on Economic, Social, and Cultural Rights of the two-week rule, the Immigration Department persists in its implementation. In fact, the Immigration Department, in its recent accusations on job hopping of migrant domestic workers, has forced migrant domestic workers who wish to terminate their employment contract to endure violence and inhuman treatment of their employers rather than face the risk of losing their job. Bethune House strongly recommends to the Hong Kong government, 1, to immediately review the new condition of stay or two-week rule as recommended by local human rights organizations in Hong Kong and even the Committee for the Elimination of Discrimination Against Women of the United Nations. Reform or repeal clauses that are discriminatory and promote conditions for abuses and exploitation. 2, rescind the new policy of denying visa to applicants based solely and arbitrarily on records of incompletion of employment of the 2-year contract. This does not take into account the particular conditions that result to termination of contracts and unjustly penalize both foreign domestic workers and employers without due process. 3, provide full support and shelter to migrant women workers who are victims of abuse and exploitation. Thank you.
Thank you. Next, United Indonesians Against Overcharging, Ms. Nurjanati. Thank you.
Thank you very much. Many foreign domestic workers in Hong Kong are forced by their respective country of origin government to go private recruitment agency before getting work in Hong Kong. All are recruited or by law to go to agency whether they are newly hired or hired for the first time with renewed contract or returning with a new employer after a pre-terminated contract. Among all three, only the newly hired have to go through their employer agency in their country of origin before going to the counterpart agency in Hong Kong. This process that many foreign domestic workers experience being charged illegal fees by recruitment agency. By illegal, we mean they are being charged more than what the law in either the country of origin of Hong Kong allow. The new Indonesian domestic workers, upon their arrival in Hong Kong, immediately handed over to their agency in Hong Kong. In the next day, the newcomer will be brought to a financial agency, forced to take a loan, usually $6,500, to give monthly repayment of $2,500 to $3,000 Hong Kong dollar for 6 months. This loan does not go to the hand of the Indonesian domestic workers. For those with contract renewal or pre-terminated contract, Indonesian domestic workers with contract renewal or with pre-terminated contract still have to go through to counterpart agency for their Indonesian peace recruitment agency in Hong Kong. Most agencies charge agency fees $6,000 to $8,000 to be paid either in full or installment for 2 until 3 months. Thank you.
Thank you. 跟住係天主教正義。
Next, Justice and Peace Commissioner of the Hong Kong Catholic Diocese, Mr. John Zhong. Thank you, Chairman. Now, based on the Bible's teachings, we have been paying attention to the incidents and the abuse of foreign domestic helpers. There are a lot of scandals surrounding foreign domestic helpers. The EAs are forcing FDH to sign contracts to take out loans, and when they're unable to repay loans, the financial companies threaten to cause nuisance to employers.
And actually, they can also tell the employers that you don't have to provide any rest days within the first half year, or you can just pay the FDH $2,000, or you can pay the EA instead and also withhold passports. People say FDH are acting in a way that they want to be sacked and go to Macau. Actually, they have been convinced by EAs because EAs want to get another intermediary fee. The Immigration Department now thinks that FDH are job hopping, so they will not be given a visa next time. But actually, what has the administration done? Nothing. Our proposals are, therefore, that first of all, the administration should actively come to an agreement with the exporting countries and do away with the requirement for EAs to deal with contracts, so FDH can find new employers through friends or in the free market, so they do not have to pay hefty agency fees. Number two, the 2-week rule is giving a candle to the devil, because they have to go back within 2 weeks, and then when they come back again, they have to pay hefty agency fees. Actually, the administration does not impose this 2-week rule on other people who are foreigners working in Hong Kong. So is that discrimination? I wish that the 2-week rule would be abolished. And number three, you should also abolish the live-in requirements so FDH have more room and freedom to get in touch with the outer world. And this is the starting point for normal working hours. And number four, the administration should allow employers and employees to both undergo a compulsory training course with regard to rights of employees and also penalties for unscrupulous employers, etc. And number five, they should be able to fill out a questionnaire for the sake of the Immigration Department. And then the Immigration Department can get to know the workings of the EAs. Thank you very much. Next, Hong Kong Federation of Employment Agencies Limited, Ms. Wendy Lau. Thank you, Chairman and members. I think it is time for us to review the policy of FDH since it has been with us for over 40 years. After listening to so many views, I think you have some misunderstanding towards the EA service. Well, in fact, I haven't heard anything about the importance of the role of EAs. Let me now introduce it to you. We are an intermediary between employers and employees. We are also the bridge for communication. We help the two different cultures to get adapted to one another's difference. We also act as a mediator if there is a conflict between employers and employees. So we are just like the mediation center that is publicized on TV. Apart from working on documentation and placing of workers, what is important is that within the 2-year period, we have to follow up on any problems with regard to the relationship and other matters between employers and employees. The consulate of exporting country has very stringent requirements on EAs, and the EAs also have the responsibility to protect the personal safety and safety of property and also other rights of FDH in Hong Kong. Unfortunately, given the Hong Kong situation, the agencies have no powers to do this because under the law we are the EAR. We are not intermediaries as such, so we are not given the rights or powers to help FDH do certain things. I hope the administration can delineate the nomenclature, the duties and powers of employment agencies so that there will not be any confusion and misunderstanding. And actually, FDH is not like any other career, so we should have different licenses. I hope we can speak from the tripartite interests of employers, employees, and EAs so we can have healthy development of the market. Next, Pathfinders, Ms. Luna Chan. We are a charity. We help FDH face accidental pregnancies. There are 310,000 FDH in Hong Kong. Most of them are between the age of 25 and 35. Many of them are from very devout religious countries, and they have very little knowledge about pregnancy, and therefore there have been accidental pregnancies. Last year, amongst the FDH who came to us for help, about half of them were dismissed during their pregnancy. Maybe they do not know that there is protection for pregnant women at work in Hong Kong, and some of them resigned. So I believe we should work to take away the discrimination. Once they are dismissed, there is no protection. They have no home to go back to. They have no money to go back to the country, and also maybe they are in an advanced stage of pregnancy, so they cannot take a flight, and they can only gate crash at the E&A departments. And then after that, the administration will charge them $90,000. They are not like mainland women giving birth to Hong Kong. And in fact, even if the babies are born in Hong Kong, FDH and the children do not have the abode in Hong Kong. And where should they go? Stay out may be against the condition of stay. Would the employer be compelled, therefore, to also accept the baby? The administration pays no attention to this, and it has no regard for the employers and FDH. It doesn't keep statistics of pregnant FDH in Hong Kong. And we believe we should make 4 proposals. One, the Immigration Department should state in the contract that the FDH should also be protected even if they get pregnant during work. And number 2, you should delineate the accommodation for FDH during the 10-week pregnancy leave. And then the Labor Department should also issue a guideline to guide employers and employees as to how they should attend to this issue of pregnancy. Number 4, the Labor Department should train employers and employers to let them know their rights. Okay, thank you. The deputations have spoken. Now it is time for the Secretary to respond to the views of the 50-odd deputations. I think you have heard them. The views are on regulation of EAs, exploitation of FDH, and some say that FDH actually induce FDH to job hop and get sacked. So I will allow the administration to now respond, and then the floor will be open to members for questions to be put to deputations and the administration. Mr. Secretary, can you stay 15 minutes more? Yes, of course. So I believe we need to extend the meeting by 15 minutes. Secretary. Thank you. I think we have heard views from 2 groups, and now I'd like to give a consolidated response. Number 1, I agree that the FDH market has been with us for 40 years, and given the recent spate of incidents, we really think that we should do the regulation work even better. We should protect the interests of 3 parties. One, FDH. They are part of the labor force. They are very important part of our labor force. They are a force for productivity, so we should protect them. And also, we also have to protect the employer's interests. As for the EAs, they also have an important role to play. Some of them are very good, some of them are problematic. The standard is not uniform. We cannot say in a general statement and adopt a broad brush approach to say that the EAs are all bad. But then we have to do comprehensive and objective monitoring. Whether it be the Bureau or the department, we are focusing on the issue now. We are going to do something in the short, medium, and long terms. In the short term, we'll step up publicity education, enforcement, and also inspection. The Labor Department will also deploy more manpower. I think you have heard last year that we actually prosecuted, we suspended licenses, and we also refused to renew licenses. We'll certainly tighten up control. This year, we are going to deploy more manpower to do this. Number 2, education and publicity. We are duty-bound to do it. The employers, employees, and the administration can all work together. I won't repeat. We are going to do so in the public media. We are going to make use of Filipino and Indonesian so that we disseminate the message. And also, we would tell them not to allow people to withhold your passports. And in fact, employers have no right to take away the passports of the employees without the consent of employees. It amounts to theft, and the employers have to know this. And the employers might not know. They think, oh, it's all right for me to keep the passports. But we are going to tell employers that this is unlawful. We will publicize this on TV. And I think we need to tackle the problem at source. We keep liaison with exporting countries, and we have a very good relationship with the Indonesian consulate. I actually am in contact with their ministers. Talking about Indonesia, As you know, as I said in the first session, the crux of the problem is the high training fee and the so-called agency fee. That's the source of the problem. If the fee can be reduced to a reasonable level, and as I said, I quite boldly expressed my personal view to a visiting high-ranking Indonesian official to say that whether the Indonesian government can provide low-interest loans to FDH so that there will not be any exploitation. It's just like Hong Kong students studying in universities. They don't go to a bank to get a loan because the government gives low-interest loans to them with a long repayment period. Can, for example, FDH repay within 24 months? Now, of course, I have to respect the Indonesian government. They have their own policy, but at least we express our views. In fact, in the past period, we have been expressing our concerns, and with the efforts of organizations, it has been reduced to 13,000 from 18,000. But of course, it's still a high fee because the FDH do not have a high salary. We are very concerned about the interests of employees, and we do not allow any exploitation. And for EAs, we are thinking about doing our work about a licensing system. Say, for example, can we impose licensing conditions, including that you have to continue your liaison with new arrivals in Hong Kong and to ensure their safety. Tell them that they can go to the Immigration Department, Labor Department, and other NGOs for help. Number 2, money. EAs cannot intervene into any loans. We have to tackle this at source. If you are an EA, you are an EA. You introduce people to a job and that's it, and you should not be involved in any money matters. That's not your job. And we are going to seek the views of the Department of Justice, and we will come back to the Manpower panel. Mr. Chairman, we are thinking of a package of ideas, and in due course, we will give you a consolidated report. We're going to consult the industry. We cannot just work behind closed doors. And if necessary, we can have another hearing to listen to views. So we will tell you these are the concrete proposals which will be effective, which will be feasible. We are very happy to do that. In fact, I really appreciate you saying that families and FDHs should be working together, because the foreign domestic helper are domestic helpers. They live in the home, and you must have trust in them before you will allow them to take care of your children. So there must be a harmonious employment relationship. That's important. And number 3, you talk about live-in requirement and also the 2-week rule. As for the 2-week rule, I'd like to defer to the Assistant Director of the Immigration Department to supplement. As for the live-in requirement, why do we have to do that? It is because in the 1970s, we started to import foreign domestic helpers, and we used very generous conditions. Today, we have 324,000 FDH working in 290,000 households. There was a shortfall of local live-in domestic workers, and local women can only work part-time. They have to take care of their families, so they cannot live in. Now, since there was this very clear vacuum because of this acute shortfall, we started this very generous policy of FDH. Why is it that they can come so easily? Other people cannot come so easily. Under the supplementary labor scheme, the cleaners at restaurants and construction workers are finding it much harder to come to Hong Kong. This is because the nature of the work is different. Okay, this is a very important policy principle. I call that the cornerstone. That's the cornerstone of this policy. But if FDH are exploited, they should not swallow it. They should report the case immediately. They should make a call to us immediately. So we're sending out this message. Don't just swallow it. Get help. The administration will certainly give you justice, will return justice to you. That's our responsibility. Secondly, okay, putting that policy aside, in fact, the situation is also not allowing this to be done. If all 324,000 FDH live out, where do they live? We have a big housing problem in Hong Kong. Would there be many more subdivided units in Hong Kong? What are we going to do about it?
What about public transport? We have over 300,000 FDH coming to work and going off work every day. And there are other social problems which we must not ignore. So we understand the intention, but in terms of the practical arrangements, I hope you would understand that there is a need for this living requirement to be maintained. And one of the deputations made a very good point. Is it possible for us to reflect to the countries of origins that to facilitate them coming to Hong Kong? For example, for Indonesia, we often reflect this view to them, and that for renewal of contracts, they should not be required to go through the employment agencies again. In fact, for Hong Kong, we don't have any requirement under the law for them to go through the employment agencies again. If they just renew the contract with the same employer, then why is it necessary to go through employment agencies? For Thailand, for the Philippines, that's also the case. And I need to declare interest. I have been employing FDH for over 3 decades. Why do we need the FDH to go through the employment agency again? And who should be responsible for the fees? And I have time and again reflected this view to the Indonesian government that this requirement can be scrapped, so that we don't need to pay extra. But like I said, this is not part of the laws of Hong Kong, and we need to respect that country's policies. And as for our local laws, I hope members will understand. And I also invite Mr. Law to explain a bit further about the 2-week rule. It is important to exercise effective immigration control by imposing the 2-week rule. This can prevent FDH from job hopping in Hong Kong or breaching the conditions of stay by working illegally in Hong Kong. By having 2-week period, they can have sufficient time to make arrangements and to look for another employer. This does not affect the FDH's rights in applying to return to work in Hong Kong after leaving Hong Kong. And we do allow flexibility. For example, if the employer has emigrated or maybe due to death or economic difficulty, etc., that the employer is unable to continue with the contract, or maybe there has been evidence of the FDH being abused or exploited, the FDH may apply for a change of employer in Hong Kong without first leaving Hong Kong. And we carefully consider these applications. Now, can you respond to the point about FDH forcing or conducting themselves in a way that forces the employers to sack them? Well, we received some 6,000 applications of ending the contracts prematurely, and we approved 5,000 or so of them due to many reasons, maybe due to the employers' reasons or due to the FDH's performance. We can't be sure what constitute the major reasons, but the majority of the cases have to do with economic difficulty or migration of employers. Questions? Anything to supplement? No more? So questions from members. Dr. Fernando Zhang, Ms. Chan Yun Han, Mr. Poon Siu Ping, and Mr. Felix Chung, and Sir Leung Kwok Hong. So 6 members altogether, including myself, 4 minutes. Thank you, Chairman. We have a huge number of foreign domestic helpers in Hong Kong. This shows the inadequacies in terms of child care, elderly care, and care for the needy. If we have good child care services, if you have good elderly support so that elderly people receive adequate care at home, I don't think Hong Kong people would need to hire so many foreign domestic helpers. Now today, It takes up a large proportion in the market, and the government just relies on the market to resolve problems. We have some 300,000 foreign domestic helpers, all female, basically, at a relatively young age. And on arriving in Hong Kong, we see this ridiculous scenario of them heavily indebted even before they start work. And they need to work in domestic premises. And Chairman, I also need to declare that I am an employer of FDH for over a decade. And between employers and employees, relationship could be good, it could be bad. But at the policy level, if you don't have a system in preventing exploitation of FDHs on arrival or before their arrival, there could be problems, just like what we see now. And it's shameful because we see a spate of incidents of abuse of Indonesian helpers, and we see news on international media coverage. And for the 2-week rule, according to the Immigration Department, this policy seeks to prevent them from turning into illegal workers or job hopping. However, for expatriates and other foreign workers coming to Hong Kong under different talent admission schemes, these expatriates are also employees. They're also workers. Why are they not required to observe this rule? Why must you assume that foreign domestic helpers would job hop, but not other expatriates? These expatriates may have headhunters helping them to hop jobs. So isn't it discrimination? Why would you assume that foreign domestic helpers would hop between jobs? So my question is whether this 2-week rule is discriminatory. Mr. Law from Immigration first. We have different labor and talent admission schemes and importation schemes, and there are objectives behind these schemes. As for the 2-week rule, it has been implemented since 1987. At that time, the rule was set based on the circumstances at the time, and we find this to be long-standing and effective and established because this effectively prevented foreign domestic helpers from job hopping in Hong Kong and or for staying behind to become illegal workers after the termination of contracts. But this system is causing a plight to many foreign domestic helpers. They need to put up with unreasonable situations. Otherwise, if they don't put up with the situations, they are forced to leave. They are forced to leave the territory. Yes, does the rule force the foreign domestic helpers to put up with intolerable circumstances? Well, we have flexibility, as I mentioned, under 5 conditions. The FDH can change employer. And these conditions include the evidence of them being abused or exploited. Next, Ms. Chen Yun-han. Chairman, 2 points. One on employment agencies. I think the government should take a serious stance. It's really difficult for me to comprehend how they can take out such a huge loan in Indonesia before coming. It's just like being sold as slaves, and yet the Hong Kong government doesn't do anything. I don't know what happens in between, but as a migrant worker coming to Hong Kong and work in such a manner, I think the government should look into it. It's like they're being sold off as slaves. And when they come to Hong Kong, some fees will be charged. And again, all things must be clear. Sometimes I hear from the news and I find this outrageous. Employment agencies
exist, and some of them are not accredited by the Indonesian government. How can we tolerate the existence of such? I agree with one of the labor union representatives that there should be a tripartite meeting held led by the government. The employers and the workers may be confrontational. It's good that we have a meeting between the government, employers, and FDH. I think it is necessary for the government to resolve this ill sentiment. We must not assume that every foreign domestic helper would come and steal things and so on and so forth. I need to declare that I also hire foreign domestic helper for my mother. And sometimes, during the last session, I asked Mr. Law, why can't he agree to the tripartite meeting? He just rejected the proposal outright. It's a labor issue. It's an important issue under the Labor Department. It's pointless to remain confrontational. Thank you, Ms. Chen. On employment agencies, we agree that we should consider seriously. Don't just start to consider it. Do it at once. Don't allow employment agencies which are not accredited or duly registered to operate in Hong Kong. Now, on employment agencies, we are going to introduce licensing conditions which will effectively step up regulation. When? Well, we are going to seek legal advice from the Department of Justice first, and like I said, we'll report back to this panel and consult members, and then we will consult the industry, because we have employment agencies in Hong Kong. We need to consult them as well. We can't work behind closed doors. There'll be a consultation process. It's an interactive one, and we don't have all the say. We must get acceptance from the community, from employers and FDH, for good employment agencies to continue to operate in Hong Kong. And on communication, maybe I'll defer to Mr. Chan, Assistant Director, Labor Department. One more important point about overcharging. On the Indonesian side, I don't know who is charging the fees. It's just like being sold off as slaves. On overcharging, I don't mind repeating this point. We are concerned. We think that we should be concerned about it, but we have limited jurisdiction. Well, if some countries have this system, we should not import foreign domestic helpers from that country. We have expressed concerns, and I have been secretary for quite some time, and in the Geneva meeting, I have been reflecting the same view as well. The required fees have gone down to some 13,000 only. Of course, it's still high. Now, I want to emphasize, Chairman, if there are problems with that country, we can allow other countries to export foreign helpers instead of just that one. All right, time is up, and this paper shows very clearly the IOU note and the repayment record, how the loan is taken out. Of course, everything is done in Indonesia. I hope that you would delete the name. I omitted this procedure. I should have deleted the name before circulating it to the member. So the employee's name should be deleted. Next, Mr. Poon Siu Ping. Thank you, deputations, for coming to give your views. Now about employment agencies and FDHs. FDHs and employers have concerns over the employment agencies. Now there have been suggestions that licensing conditions be imposed to regulate EAs. And I agree with Dr. Fernando Jiang that nowadays we have over 300,000 foreign domestic helpers in Hong Kong because of the inadequacies in our child care services, in our elderly care services, and many housewives are prevented from going to work because of these constraints. So these foreign domestic helpers contribute to our society, and the Secretary mentioned short, medium, long-term measures. For the short-term ones, maybe it has more to do with publicity.
The administration said that you would
look into the monitoring of EAs, and you say you would talk to the DOJ. So what is the timetable? Would there be a time limit, for example, that we would go in this direction within the year? Some deputations have said that we should learn from Singapore, that it is transparent and open, and there is a demerit point system. Will you consider all these? Thank you, Mr. Poon. We have an open mind at this stage. That is why today's hearing is very useful. We have read the submissions, and there are many concrete proposals. We'll go back and consider them all, including what I said, that EAs should follow up on new arrivals within a certain period of time to see if FDH are in difficulty. And secondly, money matters. The EAs should not be involved in any taking out of loans. In other words, EAs should never be involved in loans. I think that is to tackle the problem at source. And the demerit point system, yes, we can consider it. We do not rule out any possibility, as long as it is feasible and as long as it is not too much constraint on EAs. You know, EAs are legal business in Hong Kong, so we'll try to strike a balance. But the important thing is to protect employers, employees, and the EAs, which should be given room for maneuver. But then there should be sufficient regulation. As for inspections, how are you going to step up inspections? To what extent are you going to do it? Can I ask the Commissioner to say something? Also, you should explain about resources. How much resources do you have to do inspections? And secondly, the Secretary said this, and Mr. Poon also said something. If you know that a loan has been taken out, do they break the law now? Or is it that you would make it an offense later? If today it is seen that a EA is arranging a loan, then the EA would become a loan shark. Then will you do anything? Thank you, Chairman and Mr. Poon. We will be deploying resources. We have increased manpower, and we will ask retired policemen to walk along our inspectors during inspections. In the past few years, we have been stepping up monitoring, and in fact many EAs in Hong Kong know very clearly that they should not be involved in loan taking. Very often, when FDHs come to Hong Kong, they would have already signed agreements with their local agencies, and they come to Hong Kong to repay the loan, and there is no evidence to show that the money has gone through Hong Kong EAs. No, the question is, if a loan is arranged by a local EA, and we have seen evidence submitted by some deputations. So I'm talking about now. Is it that you can already take action now? And also something else to be clarified. Now, I know the topic very well, but will you have the same inspectors looking after arrears in wages and EAs? If you have just the same group of people, then you are not doing many inspections. No, we have different teams of people. We have an EA team. How many people are there in that team? We also have other teams to inspect other companies. But of course, the urgent task is to educate FDHs to lodge complaints. Because even if you inspect the EAs, you don't know whether FDHs have been experiencing arrears in wages or withholding of passports, etc. So if indeed we know that a local EA has taken an FDH to take out loans, then that would be against the moneylenders ordinance, and we are going to ask the police to follow up. So we will educate the EAs as well. We like to emphasize that the Labor Department has stated in the licensing conditions that we should protect employees from overcharging. And now, of course, the complaint is the quality of service. And in the past 2 years after we have a new trade descriptions ordinance, the Consumer Council and the Customs and Excise Department have stepped up their control. We hope we can protect employees and then we can also protect employers. As for EAs, we want to be able to monitor them in a lawful way. Next, Mr. Chung Kwok Pan. Thank you, Chairman. Thank you, deputations. As the Secretary said, the laws were made 20, 30 years ago. There needs to be a comprehensive review. And we know that there are conflicts between government departments. Say, we hire an FDH. The Labor Department says we should provide an air ticket for FDH to go back to the country of origin. But last week I asked the Immigration Department. It is said that because of the immigration ordinance, the FDH just has to leave Hong Kong. So many of them go to Shenzhen or Macau. Therefore, when we hire the FDH, it is said that we must provide passage for them to go back to the place of origin, but we have no way to find out where they go. Can the two departments tally your work to plug the loophole? Second question. I'd like to thank one deputation for giving us this form so we understand more what FDH from Indonesia pay before they come to Hong Kong. We understand that the SAR government cannot say anything about what the Indonesian government does. But we are sure of one thing. In fact, the EA fee should be $401 only. But we all know, and one deputation also said, it is now $8,000 to $12,000 for the employer. And maybe that includes all these fees of different names. Well, according to the employers, employees pay $13,000 and then employers pay $8,000. So altogether $21,000. There are two sums. I believe most Hong Kong employers do not know that they only need to pay $401. Most of them think that the intermediary fee is $8,000 and so they just pay. Now, how can we protect Hong Kong employers and their rights so that they know they need not pay so much? And now when you hire an FDH, you have to pay like $20,000. That's a big problem. Two questions. One, conflict between departments, and two, the fee of $8,000. Let me clarify something. Mr. Zhong, I think you have misunderstood it. The law is very clear. The EAs can only get 10% of the first month's salary of the FDH, and that is $401. The employer's fees are service fees. That is not regulated by law. No regulation at all. It can charge you $8,000, $5,000, or $10,000. It's up to the company. It is business. Therefore, how much the employers pay, that is not regulated at all. But if the EA charge the FDH more than $401, that's against the law. So it's $401. Secondly, that FDH only go to a nearby place and come back. I will ask Mr. Law to say something. We encourage employers not to give cash, but a ticket. If you pay cash, there will be problems. If you give a ticket, you should make it non-transferable so as to make sure that they go back to the place of origin. Please be very brief because of time constraint. Thank you, Chairman. Well, it is a flexible arrangement. For the employers or the workers, they have their own needs. Sometimes employers need to terminate the contract. And sometimes they also need to hire urgently. Sometimes FDHs are terminated not because of their own fault and they need another job. They don't want to go back. So when we handle these cases, we like to facilitate both parties. Mr. Leung Kwok-ong. Chairman. First, I'd like the Immigration Department to confirm something. You say there are a few thousand cases where there is termination of contract. You did not say anything about FDHs wanting to be sacked. How do you categorize the cases? Because, well, yes, you don't have a category of FDH who are doing anything to get sacked. Can you let me know more about that? Actually, whenever we receive a case, we don't immediately categorize it as wanting to get sacked because termination of contract may not arise from a problem with the FDH. We would look at the 12 months preceding the termination of contract and to see whether there has been any job hopping. Starting from August last year, what we do is if there have been 2 applications for a new employment in the last 12 months, we will take a closer look. We suspect 1,372 such cases. And then we took a closer look and we saw that indeed 170 such cases are substantiated. Of course, we will listen to the FDH. We also seek evidence from the employers. We would try to tally the figures. So we cannot say with a broad brush statement that every case of termination is a case of the FDH hopping jobs. Now, can I please ask you this? After termination of contract, some people say they just go to a nearby place and come back for a job. Is that possible? As I said, termination is done on different grounds, and employers and employees have their own needs. And indeed, we don't rule out the possibility of FDH coming back within a short while to start another contract. So you are not requiring employers to give them an air ticket to go away? If it is an air ticket, then they really have to go back to the country of origin, is that right? Yes, as the Secretary said, employers should not pay cash, but an air ticket. So the employees will not stay in Hong Kong. So I think I have got my answer. My question for the Bureau Secretary is, now of course I know that Indonesia is an independent jurisdiction. But if there are sweat factories in the world, we ask people not to buy those products. But if you have a sweat labor force, why do you want to patronize it? We are a party of the International Labour Organization, and this shouldn't be the case. You should tell the Indonesian government that they should do better, or else we are not going to import their workers. All right? If you take this to be broadcast on Al Jazeera or even BBC World Service, and that is what you said just now, it will be disastrous. So you should not allow a labor exporting country to slave drive their workers. Do you agree with me, Secretary? So do you think that if you cannot do anything about the charging of fees by Indonesia, then you will not import Indonesian workers? Because of time constraint, can you allow the Secretary to answer you? As I said, we have been expressing our concerns to the Indonesian government. We also understand that they know our concerns and they have promised that whatever that can be done will be done. Secretary, give me 5 more minutes. It's almost 45 minutes past 5.
Now, you should make it clear to them that if this goes on, you will stop allowing their foreign workers to come, because it's ridiculous. If you say you are ignorant, then you have no knowledge, then I can't say. But this is rare anyway. But this is not uncommon. You have this loan receipt. I really don't want to start a quarrel with you. Secretary, I believe you have heard him loud and clear. Please tell your counterpart we have strong views here that if this continues, this kind of exploitation continues, then there are voices here suggesting that we should ban the importation of Indonesian domestic helpers. I'm not saying a blanket ban, but there should be an improvement, because the Indonesian companies over there are causing this trouble. So finally, several points. Just now I heard Secretary mentioning that the foreign domestic helpers should not tolerate in silence. So you're suggesting them to come out and report the cases. So after reporting those cases, where will they live? After reporting that on their employers, they are in heavy debt and they have no accommodation. Of course, they need to observe the 2-week rule. Well, let's say they can ask for extensions throughout the period. No support is given to them, none at all. Will the Hong Kong government provide any support to these 300,000 foreign domestic helpers should they be subject to any abuse case? Political asylum, that is possible. So any asylum treatment to them. And secondly, Director mentioned just now that there will be investigations. What about the number of inspections and the staff involved? How many staff members are involved in inspections? Do you look at their books? Do you look at their loan activities? Do you investigate into whether passports are being withheld? And thirdly, Secretary, you mentioned that on regulation you will come back to this panel. What about the timetable? And fourthly, many deputations would like to meet with Secretary, labor unions in particular. So would you also consult the labor unions? They find it difficult to invite you to come to meetings. Thank you. I'll ask Director to take your question on manpower and other technical points. Now, we encourage foreign domestic helpers to report abuses, and where will they reside afterwards? Now, under normal circumstances, many NGOs provide service, but the funding doesn't come from the government. Yes, there are many NGOs. I don't need to recite their names. I believe foreign domestic helpers are familiar with them. And for employment agencies, many of them offer hostels for them for their short stays. But will the government provide resources to give them shelter? Because for NGOs, they need to raise funds as well. I think that the crux of the matter is whether you have organizations offering this service and whether there is funding support. The message is they should not put up with it anymore. They should come out and report abuses. Well, maybe they should reside at your place. And about tightening up the regulation is difficult. Let's say no loan activities. Legislation is required, and we will extensively consult the sector and seek your views. We will not drag our feet. We hope that by a year or so we can come back to report to the panel. And in the interim period, we can also come back and report our progress to members. The main message is that we must improve regulation. Director. We conducted more than 1,300 inspections last year, Chairman. In the coming year, we hope to conduct 1,800 inspections, and during the inspections, we also draft a code of practice to check whether there is any withholding of commission, overcharging of commission, and withholding of passports, etc. Now, of the previous 7,000 cases or so, you failed to investigate into any money borrowing activities, and it's very prevalent. Had Ariana's case not appeared on New York Times, you would not have paid any attention, even if we complained about it for many years. Well, that's not a fair statement. We have stepped up inspection and investigation, and on the face of it, I mean, several years ago, the EAs would charge commissions, and employers withholding passports will also be prosecuted. We will not tolerate any instances of domestic helpers being forced to take out loans. We encourage them to speak out. No more questions? We've heard that loud and clear. Perhaps, Secretary, and at the next stage you will be consulting the community again. So please communicate with employers, associations, and labor unions. And I see many deputations have asked questions on this occasion. So please give us a response in writing afterwards, Secretary, so that we can continue our dialogue in the future. Thank you, deputations, for attending. Thank you, administration.